will be used against you. So please, if you have to discuss anything about your case, seize that moment to talk with your attorney. Speaking of attorneys, you have the right to an attorney. You cannot afford one. One will be appointed to represent you. Today, we have public defense counsel who are seated in courtroom 2. We may or may not have some conflict attorneys joining us. Our pretrial officer is Ms. Tyson. Probation revocation will be Officer Allison. So let us begin with Mr. Haddad. Good morning, sir.
Good morning, Judge. How are you?
Fine, thank you, sir. And is Deputy Francois or is another deputy? And
Yes.
here she goes, Deputy Francois. Good morning. Okay, good morning. Shall I take ACDC first? There seems to be one case there.
Yes, please. Thank you.
All right. Deputy Milton, happy holidays, and thank you for
Good morning,
joining
Your Honor.
us. Yes. Who do we have?
Good morning, Your Honor. Good morning. 31 through 35, Ms. Amber Scales.
Okay. Mr. Haddad, is that your client?
It is, Judge.
All right.
And she's submitted the plea paperwork yesterday afternoon or evening.
Okay. Sounds good. This is State versus Amber Scales. Good morning, Ms. Scales. My name is Judge Lal, and we are going to be addressing your cases, a couple of which appear to be bench warrant matters. So if you please be patient with me. You have been advised of your right to remain silent, and your attorney is Mr. Jawan Haddad. Do you see Mr. Haddad on the screen?
Ms. Scales, can you hear us?
Ms. Amber Scales, if you can hear me, please raise your right
Yes.
hand. Please raise your right hand if you can hear me. Perfect. Okay. Can you see your lawyer on the screen,
Yes.
Mr. Haddad? Yeah. Can you see your lawyer?
Yes.
Okay. And this is going to be a negotiated plea, Mr. Haddad?
It is, Judge.
Ms. Falk and Ms. Haddad, I have a feeling that the audio may be a little time delayed with ACDC. So we may have to wait a few moments for her response, okay? All right. Ms. Scales, it appears that you will be entering into what we call a plea with regards to the cases brought against you. Do you mind if I place you under oath? Okay, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Can you repeat?
Yes.
Thank you. All right, can you put your hand down? You just may have to speak a little louder so that we can hear you, okay?
Yes. Yes.
Thank you. The cases brought against you, 20 CR 5509D, include one offense of simple battery, family violence from November 7th, 2020. The second case is 21 CR 00083D, involving one offense of simple battery against a police officer and one count of obstruction of an officer from February 19th, 2021. The third case is 23 CR 007902D, one offense of criminal trespass causing damage to property from November 29th, 2023. The other two cases are bench warrants. The first one is 23 FTA 1148, and the second one is 23 FTA 001149.
Hey, I gave you a mask, folks. Put more.
Oh, excuse me. All right. So, Ms. Scales, your attorney is Mr. Haddad. This is going to be a plea offer. Ms. Falk, good morning.
Good morning, Your Honor.
All right. And this is going to be a global offer.
Yes, Your Honor.
Please proceed.
On position 31, it's going to be 12 months served, 42 days, credit for time served, 21 days. That's going to be from December 7th, 2020 to December 10th, 2020, and November 7th to November 10th of 2020 and December 12th of 2023. The balance will be probated and there's to be no further contact with Tamara Jackson. Stay away from 3279 Renault Road, Family Violence Intervention Program, and 40 hours of community service. On position 32, the simple battery against police officer and obstruction of a law enforcement officer, that is going to be a time served plea. That's 159 days in jail from April 14th of 2022 to September 19th of 2022. As to the final case, position 33, that's going to be 12 months to serve 34 days. 17 days credit for time served from December 12th of 2023. Balance probated. Stay away from all MARTA premises and property. And we are asking that restitution remain open for 30 days. Positions 34 and 35 will be null crossed.
Mr. Haddad, are those the terms to which your client has agreed?
They are.
And Ms. Falk, position 31 and 33 are concurrent, correct?
That is correct. All counts are to run concurrent. All cases are to run concurrent with one another. So the only case that, well, 31 and 33, she will be serving balance probated.
Okay. Mr. Haddad, do you stipulate to the factual basis, venue, and ID? I don't know if I asked you that.
We do.
Thank you. Ms. Scales, have you consumed any alcohol or medicine recently?
No.
And have you had discussions with your attorney and understood the discussions?
Yes, ma'am.
Do you understand what's happening so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Do you understand that you are pleading guilty to offenses in 3 separate cases?
Yes.
All right. And do you understand that you'll be on probation to do some programs and do some community service?
Yes.
And will you be able to comply with these programs?
Yes, ma'am.
Okay, you will have to attend some classes, you have to work at some nonprofit companies, and you also have to stay away from certain locations, including all MARTA.
Yes, ma'am.
If you return to any MARTA station, you could be arrested again. Do you understand that?
Yes, ma'am.
Is anyone forcing you to plead guilty today?
No.
And I'm going to ask you some questions about your rights. If you don't understand, you need to tell me you don't understand, okay?
Yes, ma'am.
If you decide to plead guilty to these cases, you would have to give up your right to have a trial in front of a judge or a jury. Are you prepared to give up that right?
I don't know.
If you decide to plead guilty today, then that will close out your case and you will go on probation. You will never get a trial date. Are you prepared to give up your right to a trial?
Yes.
Are you prepared to give up your right to confront your accuser and face the witnesses who will testify against you?
No.
If you don't understand, you need to let me know.
I don't understand.
Okay. If you give up your right to a trial, then you will never get to sit in a courtroom and confront the people who are accusing you of these charges. Are you willing to give that up?
Yes.
Are you willing to give up your right to have the prosecutor carry its burden, its job, to prove the charges against you beyond a reasonable doubt?
No. No.
Okay, if you don't understand, you need to let me know.
I don't understand. I
Okay,
don't understand.
okay, that's fine, that's fine. If you decide to plead guilty today, you will not have a trial. That means the prosecutor will never have to do its job to prove the charges against you in a court of law. Are you prepared to give up that right?
Yes, ma'am.
Okay. How do you plead to one count of simple battery family violence from November 7th, 2020?
Guilty.
Your sentence for that charge is 12 months to serve 42 days, credit for time served 21 days. If you have no other holds, you will be released within 24 hours. You will have to report to the probation office next Thursday. Today's date is December 28th. You will report to the probation office next Thursday on January 4th, 2024, before 3 p.m. Do you understand?
Yes, ma'am.
You report to the probation office and you will begin a program called FVIP, which is a domestic violence intervention program. You must enroll in those classes within 60 days of being released. Your probation officer will let you know when you need to enroll. Do you understand?
Yes, ma'am.
You will have to stay away from this address called 3279 Renault Road in Atlanta, Georgia. Do you understand?
Yes, ma'am.
And you must complete 40 hours of voluntary service with any nonprofit agency like a Goodwill or Salvation Army or the Atlanta Community Food Bank. Do you understand?
Yes, ma'am.
And you must report to probation every month. Do you understand?
Yes, ma'am.
In your second case from February 19th, 2021, how do you plead to simple battery against a police officer and obstruction of a law enforcement officer? All right, could you repeat that?
I plead guilty.
Okay. With regards to both charges, it's time served.
I plead guilty.
Okay, I got it. Thank you. With regards to these two charges, the sentence is time served. You've served 159 days and you're given credit for the 159 days. So your obligation for these two charges are over. In your third case, from November 29th, 2023, how do you plead to criminal trespass causing damage to property?
I plead guilty.
Okay. Your sentence is 12 months to serve 34 days, credit for time served 17 days. Again, you will be on probation for this third case. You will report to probation next Thursday. And while you're on probation, you will stay away from all MARTA property. You're not to go back to any of the bus stations or train stations. And your case will remain open for 30 days in order for the prosecutor to schedule a hearing so they can decide restitution. That is still a requirement, right, Ms. Falk?
Yes, Your Honor, it is.
Okay. So don't forget to report to probation next Thursday, January 4th, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. Do you understand, Ms. Scales?
Yes, ma'am.
All right, thank you. And the bench warrants are null trust. Thank you.
Thank you, Judge.
Number 40, Mr. Webb.
Amber.
Sorry about that. This is Mr. Webb at courtroom 2. Is that correct?
That
Yes,
is,
it is.
Your Honor, I submitted paperwork on 4 cases. Technically, the calendar only has 1 case. but Ms. Falk, flagged down the other three. So we're ready on all four, Judge.
I have 4 cases listed on the calendar, and I'll read them off to you and let me know if I miss any, okay? All right. Quan Webb?
Yes,
Sorry,
ma'am.
Mr. Webb, okay. My name is Judge Law, and we're going to address a plea matter with regards to 4 outstanding cases against you. You've been advised of your right to remain silent, and your attorney is Mr. Haddad, seated next to you. The 4 cases are 23 CR 008016E, in which you were charged with criminal trespass from December 14th, 2023. The other 3 cases are 23 CR 005836E, 23 CR 006115E, and 23 CR 007275E. I gather they all involve 1 count of criminal trespass in each case. Would that be correct?
That is correct, Judge.
All right. Mr. Webb, this is going to be a plea hearing. May I place you under oath? Raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Say yes.
Could you repeat, sir? I know your attorney is, can you hear me all right?
Hey, Webb, talk a little loud. You gotta talk loud.
Mr. Webb, can you hear me all right?
Yes, ma'am.
All right. So when I ask you a question, please answer and just speak a little loudly so that the prosecutor can hear you too. Okay?
Yes, ma'am.
Thank you. Ms. Falk, what is the plea offer for all these 4 cases?
So as to the case that's on the calendar, ending in 8016E, the state's recommendation is 12 months served 28 days. The defendant has served 14 days, which is from December 15th of 2023. Balance suspended, stay away from the shell at 556 Northside Drive in Atlanta. The remaining 3 cases that we added to the calendar are all from the same location, and we are requesting time served as to all of them since he's spent the majority of the jail time on the first case. So the other cases are case ending in 5836. We are requesting time served, which is 2 days from September 29th to September 30th of 2023. The case ending in 6115E, time served 2 days from October 11th to October 12th of 2023, and the case ending in 7275E, time served 4 days from November 22nd to November 25th of 2023. That's all for the state. We would ask the defense to stipulate to venue, factual basis, and identification for the purposes of all 4 pleas.
Ms. Haddad, do you stipulate to the factual basis, venue, and ID, please?
We do.
Thank you. Mr. Webb, have you consumed any medicine or alcohol recently?
I take mental health medication.
All right. After taking your medication, are you still able to understand what's going on so far?
Yes, ma'am. It's just that I talk at a low voice. I have a hard time talking because of my colds and sinuses, stuff like that. Because I have been sleeping with the same place under the bridge, but it's already certified that I'm homeless for now.
Well, I understand that, but if you want to plead guilty today, then you will have to listen very carefully to my questions. And if I think you are doing it just to get out of jail and that you don't really believe you're guilty, then I'm not going to accept the plea and you remain at jail. So it's very important that you listen to my questions and that you answer the question before you get into an explanation. Can we agree on that?
Yes, ma'am.
Okay. Have you understood everything that's been going on so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you to plead guilty to these cases?
No, ma'am.
Are you pleading guilty freely, willingly, and knowingly?
Yes, ma'am.
And do you understand that if you plead guilty, that you will not have a trial in your cases?
Yes, ma'am.
And you will not be able to confront your accuser?
Yes, ma'am.
And you will have to give up the right to have the prosecution prove the charges against you beyond a reasonable doubt. Are you prepared to give up that right?
Yes, ma'am.
With regards to criminal trespass in case ending in 8016E, how do you plead? How do you plead to one charge of criminal trespass at a Shell gas station in case ending in 8016E? How do you plead?
Guilty.
How do you plead to the criminal trespass charges from case ending in 5836E?
Guilty.
How do you plead to trespass in case ending in 6115E?
Guilty.
And how do you plead to criminal trespass in case ending in 7275E?
Guilty.
All these cases are from 2023. All these cases involve the Shell gas station at 556 Northside Drive in Atlanta, Georgia. You do know that location, correct?
Yes, ma'am.
I'm going to put a time-served sentence on all these 4 cases. And if you return to the Shell gas station again, you will be arrested. And if I'm your judge, I'm not going to take a plea from you the next time.
That's understood, ma'am.
I am going to make you go to trial.
Yes, ma'am.
Do you understand?
Yes, ma'am.
So if you get arrested again, cross your fingers and toes that you do not see me. Understood?
Yes, ma'am.
Thank you.
Thank you, Judge.
Next case, please. Thank you, Mr. Haddad. Jail court iPhone, who do we have, sir?
We have positions 7 through 12.
Okay. Is that Ms. Abdon's cases?
It is, Judge.
If Attorney Owen Lynch is on the Zoom. Okay. Miss Grace?
Yes, ma'am.
All right, on position 3 and 4, I think, is Attorney Owen Paul Lynch. We would need to get in touch with him to see if he's available to Zoom in.
Okay, Judge.
I'm sorry, Miss Abdon, good morning. Who's your client again? Devonte Coleman?
Correct. Let me just, if I could just go get my notes.
My goodness, okay. I was wondering why the calendar was so thick today, but okay.
Sorry, Judge. All right, so yeah, it's positions 3 through. Sorry, it's 7 through 12, is that?
7 to 12, yes, that's the one.
Okay.
And your client is Devonte Coleman, who is at the jail court iPhone. All right, Mr. Coleman, my name is Judge Lal. You please remember that you have a right to remain silent. Anything you say in open court, like the open virtual court, your statements can and will be used against you. You have a right to an attorney, and representing you is Miss Rachel Abdon. Miss Abdon is on the screen titled Courtroom 2. Do you see her?
Yes.
Okay. And Miss Abdon, how are we proceeding with this matter?
Not guilty, Your Honor, and we'd like to be heard on bond.
Okay. And do you waive a reading of the accusation, Miss Abdon?
Yes.
Okay. And are you planning to file a waiver of arraignment, or would you like me to arraign the case?
I can file a waiver, Your Honor.
You can file waiver? Okay. So Ms. Strong will expect a waiver arraignment for all 5 cases from positions 7 through
12.
9 to 11. 3, 4, 5, 6 cases. All right. Okay, so we are addressing Mr. Devonte Coleman. Mr. Coleman, you have 6 cases pending against you, beginning with 21 CR 5421J, criminal trespass, 23 FTA 1145, a bench warrant, 23 FTA 1146, a bench warrant, 23 FTA 1147, a bench warrant, 22 CR 1133J, criminal trespass from February 19, 2022, and 22 CR 1134J, criminal trespass from February 23rd, 2022. Did you hear all that, Mr. Coleman?
Yes, ma'am.
Okay, your attorney, Ms. Abdon, has entered a not guilty plea on your behalf to all these 6 matters, so we will address bond. You may proceed, Ms. Abdon.
Thank you, Your Honor. I'm requesting a signature bond through the jail and that he be released to the holds he has. It's my understanding there are 4. There is one for Cherokee County, Gwinnett, Roswell, and Snellville. And he also has a felony case that is holding him right now. And after speaking with his attorney, my client advised me that they'll be heard on bond in January. And so he wanted to be able to deal with the holds and deal with this case and be released on a signature bond.
So he's asking for a signature bond in order to be released to the other outstanding open cases that he has, notwithstanding the fact that he did not appear in court on November 16th, 2023, and on July 3rd, 2023. Do I have a reason why he didn't appear in those times?
It's my understanding that he lives here. He was also staying in Chicago. He did not have adequate notice, although it was sent. It's his duty to update the court with his address. And he does apologize for that, Your Honor. So he's just asking for you to consider he be released to those holds. Like I said, there are 4 of them, and he will still be held on that felony case, Your Honor. So if he would be released to those holds if the felony case gets resolved and he gets released on that.
All right. Let me see what his.
Yeah,
Ms. Falk, yes, before I hear from Mr. Coleman. Ms. Falk, do you have any comment?
Yes, Your Honor, I do. As for these 3 cases, all of them, I believe, yes, involve Miss Christina Caldwell. So the simple battery offense is one that involved Miss Caldwell back in, let's see, October of 2021. Actually, my apologies, I'm looking at the criminal trespass. So let's go through this. So we have the offense date of February 19th of 2022 involving a criminal trespass with Miss Caldwell. A offense of February 23rd, 2022 involving Miss Caldwell. And then the 3rd offense of criminal trespass involving Miss Caldwell. And in fact, when we spoke to Miss Caldwell, she said that they are not together, they co-parent. They have had multiple cases. She actually had to have her memory refreshed by her victim advocate from the prior reports. And she said that they are fine now. It's best that they are not together, but they are doing well and are cordial. I will say in all 3 of these cases, in the incident that happens February 23rd of 2022, she was on the bed with her boyfriend when the defendant came into the room, began to fight her boyfriend, and they both ended up, her and her boyfriend both ended up fleeing the house. On the incident that happened February, excuse me, do not know where I got that from. The incident that happened back in 2021, let me see, involved a criminal trespass, again, at Miss Caldwell's residence at the time. In that case, the defendant kicked in the front door and the door frame of the residence, trying to gain entry during a domestic dispute. He began kicking the door in, and they began arguing about the co-parenting of their child. And he also began snatching things and throwing them onto the floor. And the last case, let's see. On February 19th of 2022.
I say something?
Mr. Coleman, considering the charges that you have currently open against you, I I couldn't even stress to you how many times I'm going to say highly recommend that you exercise your right to remain silent and take a moment, if you have any questions, to save that for your attorney.
Mr.
You
Coleman,
say, yeah, go ahead, Ms. Abdon.
sorry, I apologize, Your Honor. I'm not done yet. I will speak on your behalf. I'm just going to advise you to exercise your right to remain silent. This is being recorded. The solicitors are on here. I don't want you to say anything that would incriminate you.
I can't say nothing that's gonna incriminate me. I'm like, I know what's going on. You feel me? Like,
All right, Mr. Coleman,
okay, I got you.
thank you.
All right, please proceed, Ms. Falk. Sorry about
Yes,
that.
Your Honor. And in that case, that also involved him kicking in the door of Miss Coleman's residence. That's in addition to the fact that the defendant has 8 cycles out of Chicago, Illinois. The most recent one was a null pros in 2020 for aggravated assault. Also some retail theft convictions, and let's see, there was a battery physical contact conviction from 2019 where he was sentenced. And going to his history in Georgia, we have, actually, before we get to his history in Georgia, he also appears to have some charges out of Connecticut. So he had a 2018 interference, resisting, and disorderly charge out of Connecticut. He had 3 cycles out of Connecticut in total. And then moving on to Georgia, we have, let's see, 21 cycles in total. Those range from drug offenses to
A capital offense,
hit
yes.
and run and a capital offense. I wasn't going to state the offense on the
Thank you.
record, but
Mhm.
needless to say, he has been quite busy, and in fact has missed 2 court dates involving the 3 criminal trespass cases, has 3 foreign holds outside of this county and the capital offenses. There is not, I don't think, a single compelling reason as far as the Ayala factors are concerned that he would actually meet at this point. And so for that reason, we are asking that the bond remain as set.
Ms.
Your Honor.
Abdon, yes.
Thank you. So the bond for these 3 cases is currently set at $16,000. He cannot make that bond, Your Honor. He was working at FedEx, and he also does music. He does not have income at this time. He's been held in jail. He will continue to be held in jail on the felony case and will need to deal with these holds. He has a child, Your Honor. He has responsibilities. He's been in jail for some time now on these cases. He does maintain his innocence. I understand he does have a history and a history involving the complaining witness. It's my understanding that at the time they were breaking up, moving, living separately. And that is kind of what led to all of this. And it's my client's position that that was all, these cases are a misunderstanding. And that is why he's entering this not guilty plea, Your Honor. So I am requesting, again, a signature bond through the jail that he be released only to those holds if Your Honor is inclined, and if not, a reduction in the bond so he can try to be able to make it, so he can, like I said, deal with those holds and move on with his life, Your Honor.
Okay.
Your Honor, I do apologize. We would
No,
just
that's
be-
all right, Ms. Falk. I'm prepared to rule.
Oh, no, I just wanted to sound for Miss Caldwell, just in case she is
Oh,
present
Miss
today.
Catherine Christina
Yes, I'm here.
Caldwell. You're
I'm here.
Okay.
Yes.
Um, are you dressed?
Yes, ma'am.
All right. What would you like to tell me? I really honestly don't really want to have you say anything unless you feel compelled to say something.
Yeah, I honestly feel like we have been dealing with these cases for quite some time now. I don't feel like Devonte is an endangerment to me or my child. Prior to those cases that we did have together, we haven't been, confrontational. We haven't been at it. We separated with
When's the last time you saw him? When is the last time you saw him?
right before he went to jail. We actually do great at co-parenting. He had
Again,
my
I'm going to
son,
ask you this question. When is the last time you saw him?
about December 8th.
Okay. So he's you're co-parenting, and so he's living in Atlanta?
Yes, ma'am.
Does he live with you?
No, ma'am.
Okay. And you do understand that he doesn't show up for court. He hasn't shown up for court at all this year.
Yes.
Okay. And you do understand right now that he's got a significant serious charge against him in Superior Court.
Yes, ma'am.
Okay. So I need a very, very good reason why I should release someone like this back into the community.
Well, as his PD was saying, he does have a child that he takes great care of. He does go back and forth from Atlanta to Chicago, and after we had separated, he wasn't too stable in one place, so that's probably another reason why he didn't get his court updates. But it definitely wasn't just because he's not showing up.
Yeah, he's required to provide us with a new address so we can send him notice of his next court date. If he doesn't do that, then he's in jail.
And
Simple as that.
Your Honor, we'd be happy to provide the court with an updated address. And
Oh, I'm not worried about the address. I think I'd like the address he's listing it right now. In the 2021 criminal trespass, he was in custody for 2 days. In 2022, he was in custody for 3 days. And then he wasn't in the Fulton County Jail from March 2nd, 2022, until he got booked in on December 10th, 2023, because of these outstanding felony charges. I'm not certain where I'm getting this information that he's been in jail for a long time, because he's in jail, not because of the cases for state court, not because of the bench warrants, but because he got arrested on major felony charges. So I'm a little perturbed that you're asking me for a signature bond, given that Mr. Coleman does not meet any of the Ayala factors. He is a threat to the community. He's a threat to individuals. He has a very high likelihood to reoffend, and he doesn't appear in court twice. He moves between Atlanta and Chicago, and he doesn't want to let us know where he is. So obviously he's not going to get notices for a court date because he's moving around. He's not keeping up with his court appearances.
That's not true.
So I am really not concerned about the fact that he's got a job or a child or something, because he is a threat to the community.
Listen, y'all got all
Mr.
this
Coleman?
confused. Y'all got all this
Mr.
confused.
Coleman, one moment. So,
My child mother wrote an affidavit. She wrote an
Mr. Coleman,
affidavit.
Mr. Coleman, I will relay that to the court.
They making it seem like I'm a bad person. This is every charge y'all talking about is misdemeanors. The Connecticut misdemeanors. All
Coleman,
this is misdemeanors. We talking about my holes are misdemeanors for traffic. I don't have no violent background. We was breaking up, so a lot of stuff. Come on, what a coincidence.
Mr. Coleman, I'm gonna advise you again to exercise your right to remain silent.
Bond modifications denied.
I don't like you trying.
Please mute the screen, jail court, Miss Grace. Thank you.
Oh my gosh.
Miss Abden,
Miss Caldwell, you may leave the Zoom.
Yes, ma'am.
Miss Abden, I have position number 2 that you need to do the breakout session with Mr.
Yeah, I just need to log on to Zoom. So, thank you.
All right. ACDC, who do we have, please?
Position number 3 and 4, Frasier Kayla.
All right, 3 and 4. And then after that, we'll move on to medical. This is Denise Caldwell. Miss Caldwell, would that be your correct name? Denise Caldwell? Is that Miss Abdon? The
Yes,
young
no.
lady at ACDC?
No, that's not that person. It's
ACDC,
Mcle.
who's the young lady at ACDC?
Your Honor,
Kayla
that's
Frasier.
Frasier.
probation violation, Judge.
And Judge, for positions 14 and 15, I just have a quick announcement. We're asking for a reset to next SAP calendar on Tuesday. So I could speak with the felony attorney about the entering a plea.
What's the calendar like for January 2nd? Let me just see whether the 2nd or the 4th is a better date.
The 2nd is okay.
Okay, reset to January 2nd at 9 a.m.
Thank you.
for position 14 and 15, Andre Davis. Position, you said this was,
Your Honor, that's position number 3 and 4 on the probation violation calendar.
that's why I couldn't find it. Thank you so much. Kayla Frasier, is that your name?
Yes, Your Honor.
All right. Officer Allison, good morning.
Good morning.
May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. Ms. Kayla Frasier, my name is Jessie Law, and we are going to address your probation revocation case. Please remember that you have a right to remain silent. Anything you say in open court about the circumstances of your case, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Haddad. Do you see him on your screen?
Yes, Your Honor.
All right. This is a probation revocation case for 20 CR 2065Y, in which there was a conviction for battery family violence. Officer Allison, why are we seeking a revocation of a sentence?
Actually, before we get started with Ms. Frazier, she actually has 2 cases that she had a warrant out for probation. If we could do both matters.
Could you give us the other probation revocation case number?
Yes, it's 23 CR 000152Y.
000152Y?
Yes.
Okay, and what was the probation violation case number? If there's one.
I don't think we have one. We don't really get the PV numbers.
Okay, Mr. Haddad, did you realize that she has 2 probation revocation matters?
Judge, not until this afternoon. I mean, sorry, yesterday afternoon, Judge. But I can look it up. We're ready. I'm ready.
Okay.
And I can give me a second, Judge. I can look up the PV number on the other one, Judge, if you like.
It is, well, right now we're addressing then 2 probation revocation matters. Like I've indicated, first one ends in, first one is 20 CR 2065Y, in which there was a conviction for battery family violence from January 24th, 2023. In her other case, 23 CR 000152Y, there was a conviction also from the same date, January 24th, 2023. A disposition was entered on the same date, and the state is now seeking a revocation with regards to the sentence imposed. So, Officer Allison, what are we, why are we seeking to revoke a sentence for the battery family violence and the second case for battery?
Okay. For the one ending in 065Y, Ms. Frazier failed to she obtained a new offense, failed to obtain the law by committing a new offense of
I'm
aggravated
sorry.
assault.
I'm sorry, Officer Allison, your sound's coming through very muffled. Maybe if you a little further away from the mic, that would help.
Okay, can you
Thank
hear me
you.
clearly now?
Yes.
Okay, Ms. Frazier failed to obtain the law by committing a new offense of aggravated assault and unlawful influence of prize, fraud, or tampering with equipment or material on July 14, 2023 in Fulton County. Failed to report as directed on June 9th, 2023, June 23rd, 2023, and July 14, 2023. Did not complete a family violence intervention program. And on the other case, ending in 152Y, committed a new offense of the same charges on July 14, 2023 in Fulton County. Failed to report as directed on June 9th, 2023, June 23rd, 2023, and July 14, 2023. As of today, she has 10 days remaining on her sentence ending in 065Y. I'm gonna get how much she has left in the other case.
Should be the same, Judge, I believe.
Okay, actually, it's 10 days, and the one that's ending in 152Y and the one ending in 065Y, I have 26 days remaining in that case. Probation recommendation is to revoke the balance.
All right. So how many days left altogether? 26 days?
26, yeah.
All right. Yes, Mr. Haddad?
Your Honor, no argument, Judge. We'll ask the court to revoke the balance. She's got a felony hold anyway, that just closes out the case. But officially, there'll be an admission to the failure to report, Judge.
All right. On both matters, 20 CR 002065Y and 23 CR 000152Y, both matters will be recorded as a probation violation. She's got a balance of 26 days. I'm going to give her credit for the time she's been in jail and revoke the balance, and that will close out the case. Ms. Frazier, you will remain in jail to complete the remaining days on your probation, and then that will close out all your obligations for both these cases. However, you do have a felony hold with a $15,000 bond, so that's another matter that you would have to address separately.
Okay, Your Honor, I have a question.
Mr. Frazier, I can probably speak to you afterwards, if that may answer the question.
Okay.
Thank you. Medical, who do we have, please?
This is Roy Brammer, position 2. Miss Abden was supposed to do a breakout with her. I don't know what she's, go ahead and do the breakout.
Miss Abden, were you going to speak to Mr. Brammer?
Yes, Your Honor, I need to speak with him. I'm ready for the breakout room. I'm logged on.
Okay, if you are on your laptop, okay, Miss Grace, if you could place PD Rachel Abden panel in a breakout. Medical, you will see a message on your screen to join a breakout.
Okay, Judge.
Okay.
And your
Courtroom 2, who do we have next?
This is going to be number 42 and 43, Mr. Wiley.
And Your Honor, before we reach 42 and 43, on Mr. Brammer's case, I just wanted to point out to the court, he has about 7 open cases currently under a different name, Rico Marcel Brown and Rico Brown. And so we are going to ask if those can be reset to the next SAP calendar so we can address all of the cases at one time.
thought I had all 7 reset, but maybe that was from a different calendar. This is Adidas Wiley. He's got an AKA.
Oh, no. I was saying is to Roy Brammer, position 2.
Oh,
one
Mr.
with
Brammer, I'm
Abden
so
going
sorry.
Into the breakout.
Okay. Why don't you, well, I'll wait till Miss Abden returns from the breakout, okay?
Okay, great.
All right, sorry. Adidas Wiley is a separate matter, 42. Mr. Wiley, my name is Judge Lal, and we're going to be addressing 2 of your cases on our calendar this morning. First one is a offense of simple battery accused under 23 CR 4698B from July 29th, 2023. Then you have a bench warrant matter 23 FTA 1187. You've been advised of your right to remain silent, and your attorney is Mr. Haddad. Mr. Haddad, with regards to Mr. Wiley, this is going to be a negotiated plea. Would that be correct?
It is, Judge. I apologize, Ms. Falk. I understand I forgot to ask you, would the state agree to remove the MARTA restriction? If not, I understand, but I forgot. I meant to ask you just in terms of him being able to use transportation, that's all.
Let me check, because if MARTA gave him a suspension as part of the report, even if I lift it, he's still going to be under the same conditions. And so I would prefer not to if MARTA did also suspend him.
Well, could I do it as to stay away from all MARTA in accordance with all outstanding suspensions?
I will say, Mr. Wiley, I'm looking at the report right now, was issued a 365-day suspension effective immediately. That was July 29th, 2023.
And that's fine, Judge, and I apologize. I completely forgot to reach out to Ms. Falk yesterday.
That's
Not a
fine.
problem.
So I can amend it to stay away from all MARTA in accordance with current suspension, which means that he cannot use MARTA until July 2024.
That is correct. I believe July 29th to be exact, so.
Okay, July 29th, 2024.
Mhm.
Unless he incurs additional suspensions. So, Ms. Haddad, is that acceptable?
It is, Judge. Thank you.
All right. Mr. Wiley, as I've said, you're charged with simple battery from July 29th, 2023. If this is going to be a negotiated plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Polk?
Yes, Your Honor. The state's recommendation on this is 12 months served, 30 days, credit for time served 15 days. That's going to be from July 29th, 2023 to August 1st, 2023. And then from December 18th, 2023 until today. The balance will be probated. No further contact with Eric Hawkins, ERRICK. Stay away from all MARTA premises in conjunction with his 365-day suspension, as Your Honor is going to modify that. 8 weeks anger management and 40 hours of community service. The state would ask the defense to stipulate as to venue, factual basis, and identification. I would also like to sound for Mr. Eric Hawkins. We did speak with him and he did say he agrees with the plea offer.
Mr. Hawkins? All right. Mr. Haddad, do you stipulate to the factual basis, venue, and ID in this case?
We do.
All right. Mr. Wiley, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood everything that's going on so far in your case?
Yes, Your Honor.
Repeat?
Yes, Your Honor.
Thank you. Are you satisfied with your attorney?
Yes.
Is anyone forcing you to plead guilty?
No, Your Honor.
And are you entering this plea freely, willingly, and knowingly?
Yes, Your Honor.
Are you prepared to give up your right to a trial in front of a judge or a jury? Are you prepared to give up your right to be in a courtroom, to confront your accuser, to challenge the evidence and the witnesses brought against you, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of simple battery?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served, 15 days. If you have no other holds at the Fulton County Jail, you'll be released within 24 hours. you will have to report to probation at 132 Mitchell Street in downtown Atlanta next Thursday before 3 p.m. That would be January 4th, 2024. Do you understand?
Yes,
Once you report to probation, you will continue to report to probation every month. While on probation, you will attend and complete 8 anger management classes. Those are one class a week, and you will begin those classes within 120 days of being released. You will also complete 40 hours of voluntary community service at any nonprofit agency, which is not a church and not a school. No contact with Eric Hawkins, and to stay away from all MARTA premises in accordance with all MARTA suspensions that are current. Presently, the current suspension requires you to stay away from all MARTA property until July 29th, 2024. If you get into any other issues with MARTA between now and then, and you incur additional suspensions, you'll be required to comply with all suspensions. Do you understand?
yes,
All right, good luck, sir. Thank you.
Thank you, Judge.
Francois, I'm moving on to, let's move to medical for a minute. Miss Abdon, are you available?
Yes, I'm ready, Your Honor.
Okay. At medical unit, we have Mr. Roy Brammer. Mr. Brammer, my name is Judge Law. Can you see me and hear me? You can.
Hey, Joe, my name is Mr. Rico Marcel Brown.
What's your name?
Mr. Rico Marcel Brown.
Okay. Miss Abdon, is your client also known as Roy Brammer?
I asked him about that, Your Honor. He stated that he's not sure where they got that name from. His name is Rico Marcel Brown.
Okay. I have State versus Rico Marcel Brown, also known as Rico Brown, also known as Roy Brammer. Sir, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Abdon is your appointed counsel. Ms. Abdon, the prosecution has asked for the case to be reset to another SAP calendar to address all his cases. In addition to this one, 23 CR 7870B, it appears that he has 6 other open cases.
That is correct, Your Honor. That is what I'm showing as well. And we don't object to that. If we can just reset it to Tuesday, so we can maybe try to get a global recommendation from the solicitor and try to resolve all these cases.
And Your Honor, I would just ask for a reset to Thursday. We're going to be kind of cutting it a little close with getting all the recommendations done for this upcoming Tuesday with the holiday. So I would just ask that we give till Thursday so that we can get all 7 done, as well as the other cases that will be on the calendar.
At this present time, with any possible pleas, would additional jail time be involved?
Based on the number of cases, yes.
Okay. I'm going to reset this to January 4th, which is a 1-week reset at 9 a.m. And Ms. Abdon, am I addressing this at the 9 a.m. calendar or any other calendar?
For now, it's just going to be at the 9 a.m. SAP. But before we move on, in this case, it looks like there was a bond order for a signature bond through the jail and that he be released to a hold. On Odyssey, there is no warrant number. Evidently, he was not released to any hold. So I was just wondering if maybe the court or the state can give me a little bit more information about what that hold may be.
For this particular case, 23 CR 7870B, he was addressed at initial appearance on December 12th. And a $2,000 signature bond.
Your Honor, I can get in touch with the jail in Colorado, am I?
And he is to be released to the fugitive hold. So that is it's a fugitive hold. So that really depends on the, if this is an extradition matter, then that's what needs to take place.
then we would, I mean, I don't know who handled this case on first appearance, but it's my understanding he has a right to an extradition hearing, so.
He does, and that is scheduled accordingly through the clerk's office and the sheriff's department.
And Your Honor, that hold is out of Colorado.
So it's an extradition matter.
Mhm.
So typically that goes through, well, in the old days, you used to go through non-complex and everyone's brought in on one calendar. They either waive their right to extradition or they ask for an extradition hearing. So that's a process that goes through in Superior Court through the non-complex clerk's office, division clerk's office. So this case is a release to the hold only. So are you, any other objection to resetting it to January 4th?
No objection, Your Honor. We'll just, figure it out once we get the remaining recommendations for the other cases.
All right, thank you.
you.
And Miss Falk or Miss Abden, if you have the other 6 case numbers at your fingertips, could you put in the chat to Casey Strong?
Yes, Your Honor.
State Court, Casey Strong.
I can go ahead and send those.
All right, thank you. Mr. Rico Marcel Brown, we will see you on January 4th. Today is December 28th. We will see you next Thursday. Please unmute. Medical. Medical, please unmute.
Oh, my credit time.
There's a lot of things why we're
Your Honor, I've discussed this with him. He's agreeable to.
Okay. Your attorney will see you on Thursday, January 4th. Thank you. We are concluded, medical. Deputy Francois, I'm going to jump to ACDC unless you have an objection, then I can.
Yes, that's fine, Judge.
Okay, just chime in if you want me to address a case in courtroom 2. ACDC, who do we have?
Position number 5 and 6 off the probation revocation.
Calendar?
Yasmin George.
Okay. This is Yasmin, middle initial C, George, case number 22 CR 3167F, in which there was a conviction for battery. A probation violation matter is 23 PV 1750. Ms. George, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Haddad, who is in courtroom 2. Do you see him?
Yes, Your Honor.
All right, thank you. Officer Allison, you've been placed under oath. What's the reason for the revocation in this case?
Ms. George, failed to pay probation supervision fees in total of $80, victim crime funds in total of $18, failed to report as directed on September 25th, 2023, September 28th, 2023, and October 23rd, 2023. Failed to complete 40 hours of community service, just 309 days remaining on her case. Probation is recommending for time served.
Mr. Haddad?
Judge, we're in agreement with the probation's recommendation of time served, Judge.
And how many days has she completed?
For community service?
No, for time served. How many days has she been in custody?
She has been in for.
I have 16 days.
Yes, I have 16 days also.
All right, let me just see one other thing in this case.
Okay.
All right, in this matter, she was convicted of battery causing substantial physical harm. There was a bench warrant on September 6, 2023, after which she took a plea. Not sure. Oh, September. No.
I'm sorry.
Okay. Mr. Haddad, I will accept the state's recommendation. This is going to be a probation violation recorded on her history, and the sentence would be commuted to time served. That means the obligation for this case is closed. Thank you.
Thank you, Judge. Ms. George, you got time served, you're done.
Okay, thank you.
Deputy Francois, I have an individual jail court iPhone. Shall I move there?
Yes, that's fine, Judge.
Okay. Jail court iPhone, who do we have?
Have, position number 1.
Your Honor, that would be Ms. Abden's case. I think she's speaking to another individual right now.
Is she available? Devesky Bar?
She's actually interviewing one of her clients now, Judge.
What's the position number?
Position number 1.
Yeah.
Rachel. She's coming, Judge.
All right, Devesky Barth. Mr. Barth, my name is Judge Lal. The case number is 23 CR 7769C. You are charged with simple battery at a public transit vehicle or station from November 24th, 2023. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you today is going to be Ms. Abden, and she is in courtroom 2. Do you see her?
Yes.
Okay. Ms. Abden, I understand that your client wants to plead not guilty and further notice for trial. Would that be correct?
Correct, and we do not need to be heard on bond, Your Honor.
Okay. Let me just see one thing. And do you waive a reading of the accusation?
Yes, Your Honor.
Mr. Barth, you've been accused of a misdemeanor offense of simple battery at a public transit vehicle or station. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecution would have the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state does prevail, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right, sir. Your case has been arraigned and is going to be further noticed for trial. Thank you. That concludes your matter.
Thank you.
Number 26, Pasco.
Larry Pasco is case 23 CR 008019J, in which he has been accused of loitering or prowling and willful obstruction of an officer from December 14th, 2023. Mr. Pasco, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. This is going to be a negotiated plea. Mr. Pasco, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Polk, what's the recommendation for Mr. Pasco?
Yes, Your Honor, the recommendation is on count 1, the loitering and prowling, 12 months served, 30 days, credit for time served, 15 days from December 14th of 2023, balance probated, stay away from 1426 Mims Street, 40 hours of community service. Count 2, 12 months concurrent to count 1, $300 fine, stay away from 1426 Mims Street. The state does ask the defense to stipulate as to venue, factual basis, and identification for the purposes of the plea. Are you able to hear me, Your Honor?
Yeah, I am.
Oh, okay.
Mr. Haddad, Ms. Polk was requesting if you were going to stipulate to the factual basis, venue, and ID.
We do, Judge. My client, I neglected to mention my client about the $300 fine, and that's on me, Judge. Yesterday when I met with him, that's what I was explaining to him. So is that going to be an issue? Okay.
If you want to mute your screen and just confirm that he is willing to accept that particular additional term.
We did, Judge. We're fine.
Okay. Okay. In that case, Mr. Pasco, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far in your case?
Yes, ma'am.
Are you satisfied with the services of your attorney?
Absolutely. Yes, ma'am.
And is anyone forcing you to take this plea today?
No, ma'am.
And are you entering this guilty plea in this case freely, willingly, and knowingly?
Yes, ma'am.
Are you prepared to give up your right to a trial in front of a judge or jury? Give up your right to confront your accuser? Challenge the evidence such as witnesses or documents that may be brought against you? And also give up your right to have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to loitering and prowling and willful obstruction of an officer?
I'm gonna plead guilty today, ma'am.
Your sentences for both these cases is 12 months to serve 30 days, credit for time served 15 days. You will be on probation to comply with certain conditions. You will report to the probation office next Thursday, January 4th, 2024, before 3 p.m. The location is at 132 Mitchell Street in downtown Atlanta. You will report to probation every month until your conditions are completed, and those include 40 hours of community service at any nonprofit agency that is not a church and not a school. You will also pay a $300 fine, and that's related to the obstruction charge. Any objection to non-reporting once the conditions are completed? Ms. Paul?
No objection, Your Honor.
All right. Once you've completed the 40 hours of community service and paid off the $300 fine and completed all the requirements for probation, your probation will then be non-reporting.
Thank you, Judge.
Thank you. Okay, moving on to ACDC. Who do we have?
Your Honor, that would be
Position number 30, Rodriguez Santana.
All right, I'm sorry, Mr. Haddad, what were you going to say?
I'm sorry, I was responding to the court. Position number 30, that's my client, Santana Rodriguez.
And this is going to be a negotiated plea?
It is, Judge.
All right. This is Santana Rodriguez at the ACDC location, and case number is 23CR8033C. If ACDC could please unmute, that would help. Thank you. Miss, are you Santana Rodriguez?
Yes, Santana Maria Rodriguez.
Okay. Ms. Rodriguez, my name is Judge Lal. I'd like to remind you that you have a right to remain silent about the facts of your case. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Haddad. Do you see him on the screen?
Yes, ma'am.
Okay. And just for purposes of addressing the plea that you plan to take, may I place you under oath?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Rodriguez is accused of theft by shoplifting from December 12, 2023. Ms. Falk, what are the terms?
Yes, Your Honor. The terms of the plea are 12 months to serve 30 days, credit for time served 15 days from December 14th of 2023, balance probated, that Ms. Rodriguez take an anti-theft course and stay away from the Walmart at 844 Cleveland Avenue in East Point, as well as 40 hours of community service. State would ask the defense to stipulate as to the venue, factual basis, and identification for the purposes of the plea.
We stipulate, Judge.
Ms. Rodriguez, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood everything that's going on in your case so far?
Yes, ma'am.
Okay. And are you satisfied with your attorney?
Yes, I am.
Is anyone forcing you to plead guilty to this case today?
No, ma'am.
Are you doing so freely, willingly, and knowingly?
Yes, ma'am.
And has it been explained to you that in order for me to accept the guilty plea, I have to be persuaded that you are giving up your constitutional right to a trial, to go back to court and have a trial in front of a judge or a jury, to give up your right to confront your accuser, challenge the evidence brought before you, and also to give up your right to have the state, the prosecution, try to prove the charge against you beyond a reasonable doubt? Are you going to give up these rights?
Yes, ma'am.
How do you plead to theft by shoplifting?
I plead guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. If you have no other holds at the jail from any other cases, you'll be released within 24 hours. You must then report to probation. You'll be placed on probation to complete certain conditions. Your report date is January 4th, 2024, before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While on probation, you will complete 40 hours of community service at any nonprofit agency that's not a church and not a school. You will also attend and complete one anti-theft class. At all times, whether you are active or non-reporting probation, you are to stay away from the Walmart store at 844 Cleveland Avenue in Southwest Atlanta. Do you understand?
Yes, ma'am. Just Cleveland Avenue or all Walmarts?
I would recommend all Walmarts, but the order specifically says the 844 Cleveland Avenue. Just to let you know, based on prior practice, Walmart tends to keep your picture at all stores.
Okay.
So it's up to you.
All right.
All right. Any objection to non-reporting once she completes her conditions? Ms. Paul?
No, Your Honor, sorry, got a little distracted. No,
That's
no
okay.
objection to non-reporting after she completes the 40 hours of community service and the anti-theft course.
Ms. Rodriguez, you must report to probation every month until your community service and anti-theft class are completed. And if you've completed all the requirements for probation, your probation may be non-reporting, which will save you a lot in probation fees. All right?
Yes, ma'am. Thank you.
Still stay away from the Walmart store. Thank you.
I will.
Probation 1 and 2, Allen.
All right, we're moving to medical for probation case 1 and 2. Dexter Allen is accused of theft, convicted of theft by shoplifting in case 22 CR 5950Y. And he's got a probation violation matter 23 PV 001749. Mr. Allen, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Haddad is going to be your counsel. He's seated in courtroom 2. Officer Allison, what is the basis for the revocation?
Mr. Allen failed to pay probation supervision fees in total $119, victim crime funds in a total $27, failed to report as directed on July 31st, 2023, August 8th, 2023, and August 24th, 2023, did not complete a shoplifting course. He has 155 days remaining on his case. Probation is recommended for time served.
And how many days has he been in custody now?
Let's see, because it doesn't have it here.
All right, that's good. That's fine. Mr. Haddad, do you any comment on the commuting the time to time served?
No, Judge, I would respectfully request the court to follow the probation's recommendation, Judge.
All right, I will mark this as a probation violation, given the time that Mr. Allen's already served at the Fulton County Jail. The remainder of his sentence will be commuted to time served, and his obligations for this case are complete. Thank you.
Thank you, Judge. And Your Honor, with the court's permission, if we can handle position number 9 and 10 on the revocation, Lamar Ridley.
Let me see, 9 and 10, Mr. Lamar Ridley is 9 through 12. I don't know, is Lamar Ridley available?
He's right here next to me, Judge.
Oh, next to you, okay. And then I have another one, Tyrone Johnson. Tyrone Johnson?
He's upstairs.
I'm sorry,
Mr. Johnson is behind me as well, Judge.
Okay, sounds good. Let's address all these matters on revocation calendar. First, we begin with Lamar Jonathan Ridley. Mr. Ridley, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. We have the following cases. Position 9 is 20 CR 003025J, in which you were just convicted of battery, family violence. And then we have 21 CR 7911J, in which you were convicted of another offense of battery, family violence. The two probation violation cases streaming from those two cases are 23 PV 1687 and 23 PV 1688 respectively. Officer Allison, what's the reason for the revocation request?
In case ending in 025J, Mr. Ridley failed to pay probation supervision fees in total of $80, victim crime funds in total of $21, failed to report as directed on January 5th, 2023, January 12th, 2023, January 19th, 2023, and February 6th, 2023. Did not complete domestic violence intervention program, failed to complete 120 hours of community service, failed to obtain the law by committing a new offense of driving, no headlights, improper passing of right, fleeing and obtaining to elude use of DUI, possession of marijuana, failure to signal, change of turn. It's a little lengthy, excuse me.
So you got a new arrest?
Yes, and this was on March 5th of 2023 in Fulton County. For a case ending in 7911J, he has the same new offensive that was on March 5th, 2023 in Fulton County.
The same
and the same and the same failure to report as directed, did not complete DVIP, and did not complete the 120 hours of community service. He has 127 days remaining on this case, on both cases. Probation is recommended to revoke the balance in both cases.
127 days?
Yes.
And he's been in custody now for 27 days. So he's got, if I give him credit for time served, he has about another additional 50 days to serve in order to complete his sentence in both cases. Mr. Haddad?
Correct.
Thank you, Judge. Judge, on behalf of Mr. Ridley, the dates that the probation mentioned, the fleeing and attempting to elude, it's a little bit misleading. The dates are actually from March 5th of 2022. So the offenses happened in 2022, but he was not arrested until a year later. Mr. Ridley has been in continuous custody at the Cobb County Jail since January 1st of 2023 on a charge that the probation did not make note of it, but he was arrested for possession of firearm by convicted felon January 1st of 2023. And he has been in continuous custody since then. And I confirmed that through the Cobb County website, Judge, and I can provide the court with information. So when he was arrested in Cobb January 1st, 2023, obviously he has been in custody. He's unable to report to probation. At some point there was a hold placed from Fulton County for the DUI from 2022, Judge. So he bounced around back and forth from Cobb to Fulton and back to Cobb. But bottom line is, Judge, he's been in custody since January 1st. He's got at least 2 felony pending cases, one in Fulton, which is what Officer Allison addressed, which technically predates the time of the plea, but more importantly, he's got a case from Cobb. I would just ask the court to consider closing out the case of time served. He's not really going to go anywhere for the time being, since he's still got 2 felony cases, Judge. That would be my request.
Let me just look at his. He's got an arrest in Fulton County from April 25th, 2020 for this battery family violence. He was in custody for 7 days. He was arrested again in May 6, 2020, and released 29 days later on the felony matter, including one charge of acquiring a license plate for purposes of concealment. He had a probation violation on that was recorded on April 21st, 2021, in which he was allowed to continue on probation. And then he got arrested again on December 15, 2021, on new charges: simple battery, family violence, 2 counts. And that was on December 21st, 2021. And then you are telling me now in January of 2023, he was arrested in Cobb County. And I'm not sure what you mean by being bounced around, but yeah, he did receive a
What I meant,
fee attempting to elude $5,000 surety bond. So you want me to give him credit for his probation violations because he got arrested in Cobb County on an unrelated matter?
Your Honor, I'm simply requesting that the court just close out the case. That's all I'm asking, Judge.
Okay. The grounds to close out the case just because he's in custody is not enough, not given this history. I'm going to revoke his probation, and he has 100 more days. So the remaining time left on his case is 127 days. I'm going to give him credit for 27 days. So he has 100 more days to serve out on the sentence on this case. And since the sheriff gives him 2 for 1, once he completes 50 days at the Fulton County Jail, that will satisfy his sentence for this case, and then the case will close out. Now, if he's remaining in jail because of other cases, well, that's something else we'll take up as time moves on. Thank you.
Thank you.
Position number 26 and 20.
Yeah.
I'm sorry, 27 and 28 on the regular calendar.
Okay. And who is this? Is this at medical?
Yes, this is Octavius Reese.
I am going to come back to you in just a few moments. Can I address Tyrone Johnson? Francois, is that Tyrone Johnson seated in the chair?
Yes, it is, Judge.
Okay. Tyrone Johnson is on our probation revocation calendar, position 7 and 8, case number 23 CR 155F, in which the convictions were for criminal trespass and public drunk. And the probation violation case is 23 PV 1741. Mr. Johnson, you've been advised of your right to remain silent, and your attorney is Mr. Haddad. Officer Allison, what's the basis for the revocation in this case?
Mr. Johnson failed to pay probation supervision fees in total of $120, victim crime funds in total of $27. Failed to report as directed on August 8th, 2023, August 15th, 2023, August 21st, 2023, and October 6th, 2023. Did not complete a drug and alcohol evaluation. He has 260 days remaining on this case. Probation is recommending to continue on probation and complete the drug and alcohol evaluation within 30 days.
All right. Mr. Haddad, I'll be glad to continue him on probation, and once he completes the alcohol and drug evaluation, I will put him on non-reporting probation. Is that something that your client would be interested in? That's position 7, unless he doesn't want to mark, unless he's got a good reason.
No, Judge, I would. Judge, thank you, Judge, and I communicated the court's suggestion or potential sentence, and that's acceptable, Judge. If we can just reinstate and have him take the evaluation once he's done, there'll be non-reporting.
He'll be required to do an alcohol and drug evaluation within 30 days of being released, and then if there's any treatment required, he must comply with the treatment. Once the treatment is completed, and his probation will be non-reporting. And this will be marked as a probation violation. Mr. Johnson, if you have, does he have any holds at the present time?
He does not, Judge.
All right. Then he needs to make sure that he reports to probation. Today is Thursday. He will report next. Officer Allison, is probation office open on the 2nd?
We are open on the 2nd.
Okay, he will have to report on January 2nd, before 3 p.m. And that would be his first probation visit, and he will report every month until his alcohol and drug evaluation and or treatment is completed. Once his ADT is completed, then his probation will be non-reporting.
Thank you, Judge.
Thank you.
And that concludes my probation matters. Can I be excused, please?
Yes, thank you. Thank you,
Thank
Officer
you. Have a
Allison.
good one.
Happy New Year. Take care.
You too.
All right, medical, could you tell me the number again, please? 26?
Number 27 and 28, Reese is on the regular SAP.
Thank you. Davius Reese is,
I'm sorry, Judge Law, just a quick announcement for number 21. He's going back to Cobb County, Mr. King. He's gonna be reset.
21. Okay, is that Mr. Haddad's client?
It's my client, Your Honor.
Oh, Miss Abden? Okay, Maurice George is going to be returned to Cobb County. Miss Abden, when do you anticipate we'll be able to address Mr. King's case?
Thursday, the 4th, Your Honor.
All right. Maurice King is reset to January 4th. Thank you.
Yeah. Come on, Mr. King.
All right, Davius Reese is position 27 and 28. In position 28, he's accused of battery and theft by taking in 21 CR 2185E from a May 20th, 2020 incident. This is a bench warrant matter also, 23 FTA 1184. Mr. Reese, you have the right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is going to be Mr. Haddad, who is in courtroom 2. Do you see him in courtroom 2? Unmute medical.
Yes, ma'am.
Thank you. This is going to be a negotiated plea. So, Mr. Reese, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you, sir. Ms. Falk, what's the recommendation for Mr. Reese?
Yes, Your Honor. On count 1, the battery, it's 12 months probation, serve 34 days, credit for time served 17 days. That's going to be from May 3rd, 2021 to May 5th, 2021 and December 14th, 2023 to today. Balance probated, 12 weeks anger awareness, 40 hours of community service, no further contact with Bernicia Ruff, and stay away from 520 Irwin Street Northeast, apartment A21. Count 2 is going to be 12 months to run concurrent with count 1. We are also requesting the addition of an anti-theft course on that count with the same no further contact and stay away provisions. The state would ask the defense to stipulate as to venue, factual basis, and identification for the purposes of the plea, and we would like to sound for Miss Bernicia Ruff.
Bernicia Ruff, R-U-F-F. All right. Mr. Haddad, do you enter so stipulate?
We do.
All right. Mr. Reese, have you consumed any have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And is anyone forcing you to enter a guilty plea to these charges today?
No, ma'am.
Are you doing so freely, willingly, and voluntarily?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
In your discussions with him, have you understood that if you enter such a plea, you would have to give up your constitutional right to a trial, to
Yes,
be
ma'am.
able to confront your accuser, to be able to be in a courtroom to challenge the evidence brought against you, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of battery and 1 count of theft by taking?
Guilty.
Your sentence for both charges is going to be 12 months to serve 34 days, credit for time served 17 days. If you have no other holds, you should be released within 24 hours, and you must report to probation next Thursday at 132 Mitchell Street before 3 p.m. That's next Thursday, January 4th, 2024, before 3 p.m. While on probation, you will complete a 12-week anger management class, and you must begin those classes within 60 days of being released. You will also complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. For the theft by taking, you will also complete an anti-theft class. Do you understand?
Yes, ma'am.
At all times, when you're on probation, you are to stay away from 520 Irvin Street, apartment 21 in Atlanta, Georgia. You're required to stay 200 yards away, which means that you probably have to stay away from the whole complex.
Yes,
And you're to have no contact with Bernicia Ruff. That means you can't see her in person. You have to stay 200 yards away from her. Do not communicate with her by phone, computer, or any other means, including social media. Do you
Yes.
understand?
Yes, ma'am.
All right, that completes your sentence. Thank you.
Thank you, Judge.
And what's that, a null cross? Yeah, there's a null cross on the FTA. Okay. Jail court iPhone, who do we have?
We have position number 16.
Miss Abden? This is State versus Demetrius Hatcher. Miss Abden, is this still going to be a non-negotiated plea, or is this going to be a, have y'all resolved the issues in dispute?
We have not resolved it, Your Honor. It's going to be a non-negotiated plea as to the restitution and fines.
Okay. Mr. Hatcher has got two open cases, and the first one is 23 CR 007855E, State versus Demetrius Hatcher. Charges are hit and run, failure to stop at or return to the scene of the accident, DUI, driving under the influence of alcohol per se, and driving under the influence of alcohol less safe. This stems from a November 27, 2022 incident. His second case is a 2019 offense of battery causing substantial physical harm. The case number is 22 CR 003029E. With respect to both cases, Mr. Hatcher, you have a right to remain silent. Anything you say about the facts of both cases, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Rachel Abden. This is going to be a non-negotiated plea hearing, which means that the prosecution is going to give their recommendation and articulate the alleged factual basis for their recommendation. And then your attorney is going to give me an alternative recommendation. Based on the two arguments, I will let you know which option I'm going to select, keeping in mind that I have a right to disregard either option and have the case set for trial. I will let you know which option I'm going to select before you make your decision as to whether you still want to proceed with a plea. Ms. Paul?
Yes, Your Honor. Starting with the first case on the calendar, which is the which is the hit and run duty of driver to stop at the scene of an accident, DUI and DUI. The facts on this case, Your Honor, are that this incident happened December 26th of 2023. On that date, we did have an opportunity to speak with the officer, and we will not be asking for any restitution in that case due to the fact that the defendant appeared to hit a curb. However, according to the accident report, the defendant made contact with the curb at the entrance ramp to Interstate I-85 North and Flat Shoals Road. Contact was made with him. He then fled the vehicle and left the vehicle on Flat Shoals Road. Let's see.
That's what we'll notice too.
Additionally,
go ahead.
Sorry. Additionally, when the individual when the officer made contact with him, the defendant had a blood alcohol concentration level of 0.08 or more at the time of the accident. So therefore he was charged with DUI per se as well. Finally, the defendant, because that's all on that case. The state's recommendation as to this case is 12 months probation on count 1, concurrent to count 3, 38 days to serve, credit for time served 19 days, from December 10th, 2023 to today, balance probated, $300 fine, defensive driving course, no alcohol, drugs, or weapons. Count 2 would merge with count 3. Count 3 would be 12 months to serve 38 days, credit for time served 19 days. That is from December 10th of 2023, balance probated, ADET, DUI risk reduction, a $600 fine, and 40 hours of community service. And Your Honor, let me just look at this really quickly because I'm only showing 3 counts.
No, you're right. This is 3 counts. The hit
okay,
and run was with the failure to stop.
Right. Okay. Just wanted to make sure that I was on track on that because it looks as though there were 4 briefly. All right. So the defendant's history on this particular matter is extensive, especially where it comes to fleeing and eluding. In 2012, the defendant was convicted, given 12 months for giving false name, driving without a valid license, fleeing and eluding, hit and run. In 2014, fleeing and eluding conviction, driving, let's see, with license suspended. He was given 12 months on that case as well. And then in 2023, this year, the defendant has a 4 counts was arrested for 4 counts of cruelty to a child in the first degree, use of firearm during a commission of a felony, fleeing and eluding, and driving while license suspended. So there is a history here, Your Honor, of the defendant driving in a manner that is frankly reckless and with reckless disregard for other people on the roadway, which is why the state made that recommendation. As to the other case that we have, that is a case that we pulled up in the system, which is a 2019 offense. That's going to be 22 CR 003029E. In that case, Your Honor, that is a battery charge. And in that case, the incident involved this defendant, and he struck Mr. David Kenneth Jolly with a closed fist, causing his lip to bust and bleed and swell. The relationship between him and Mr. Jolly is Mr. Jolly was at a bar at 262 Far Road. The bar's name is Blue. He said that he had bumped into a male that was standing at the bar, which was the defendant. In doing so, he advised that he turned around to apologize. At that point, the defendant began cursing at him. They had a verbal altercation, and then Mr. Hatcher, the defendant, struck Mr. Jolly in the mouth with a closed right fist. And at that point, Mr. Jolly then struck the defendant in the head in self-defense. There was an officer who was at the scene, and they were advised by security of what happened. And when asked the defendant what happened, he advised he was ordering drinks when Mr. Jolly bumped into him, and he turned around, got into an argument, and then took a swing at Mr. Jolly. He stated he was not attempting to hit him, but was only trying to shield himself. A security guard who did see the incident stated Mr. Hatcher was bumped into, Mr. Jolly did turn around, the two of them got into an argument, and that it was the defendant who struck Mr. Jolly before Mr. Jolly struck the defendant. So there is a third party who did advise police that the defendant was the primary aggressor in that case. In that recommendation, we are recommending 12 months with 30 days to serve, credit for time served 1 day. That's from July 21st, 2019 to July 21st, 2019, balance probated, 12 weeks anger awareness, 40 hours of community service, No further contact with David Kenneth Jolly. Stay away from Blue, which is the bar at 262 Far Road Northeast. No alcohol, drugs, or weapons, and no firearms. I will say that as far as his history is concerned with violence, the defendant does have a simple battery conviction from 2016, as well as a battery substantial physical harm, that is this case, as well as the cruelty to children and the use of a firearm case from 2023. That's all for the state.
Ms. Abden?
Thank you, Your Honor. So for the first case that's on the calendar, I guess I wanted to be heard on the restitution, but it sounds like the state is not proceeding with that. So in terms of the fines, he is unable to pay, Your Honor. I just would like the court to consider converting the fines to community service, if possible. There are substantial conditions for him to take classes as part of this plea, Your Honor. So I do understand there is a history of driving offenses, and I believe that the recommendation will remedy that. I'm not sure if I misheard ASG Falk. The total recommendation, it's my understanding that it would be 12 months probation, served 38 days, credit for time served 19 days, correct?
That's for the traffic matter.
Correct. I just wanted to make sure.
That is correct.
Okay, so we are, go ahead.
Sorry, he is time served as to the first case. It's the second case where we are asking for additional time.
I just wanted to confirm. Thank you. So with the first case, Your Honor, we're ready to proceed with the plea. I would just like Your Honor to consider converting the fine to community service.
And he's fine with the additional time at the jail. He has 29 more days to serve at the jail.
As for the second case, the 2019 battery case, if possible, if I could just go into a breakout room with him just to confirm that he wants to proceed on the second case.
Oh, okay. You need to get back onto your laptop.
It's across, it's right there. So whenever they.
Okay. And jail court iPhone, you're going to get a message on your screen to join a breakout so that Mr. Hatcher may discuss the second case, the battery case with his client, with the client. Thank you.
So that's jail court iPhone judge and Ms. Abden.
Yeah, jail court iPhone and PD Rachel Abden, please. Thank you. Okay. Mr. Abden, is that your client in courtroom 2?
No, her client is in, yes,
No,
actually it is.
not Mr. Abden, Mr. Haddad. Is that Mr. Haddad's client in courtroom 2?
This is actually gonna be, Ms. Abden's case.
Okay. What about medical? Mr. Haddad, is that your client in medical?
No,
This
Judge.
is position number 3 through 6, Mr. Cardwell. I don't know who his attorney is.
It's Ms. Abden. Judge, I've actually technically completed my pleas. I do have a couple announcements. I can address those with the court's permission while we wait for. Ms. Abden.
Okay. Yes. Just, okay, now, we're going to address Mr. Haddad's cases. In the meantime, position 3, 4, 5, and 6. Ms. Grace, have you had any luck with attorney Owen Lynch?
No, ma'am. His email came back undelivered. I sent him a text as well, and I also tried him, but it went straight to voicemail.
Yeah, he's actually moved on to another firm. Unfortunately, his request to withdraw from cases involving Denise Caldwell were denied by Judge Morrison. He probably need to, yeah, he probably need to submit another request in compliance with State Court Rule 4.3. But in the meantime, we are going to appoint Maureen McLeod to represent Denise Caldwell.
Okay, Judge.
And the case is reset to January 4th, 2024. Positions 3, 4. All right, so Miss Grace or Miss Strong, can you make sure that you contact Miss McLeod and let her know this is going to be another one of her clients for January 4th.
Will do, Judge.
Thank you. Because otherwise, I'm not going to have Caldwell just sitting out there waiting for someone to talk to him. Okay, Mr. Haddad, you start with position 25, would that be correct?
That is correct, Judge. On position number 25, I'm respectfully requesting a reset to the 4th next Thursday. I'm having our social worker interview him to see in terms of his competency, whether we need to put him on a competency calendar or not. But for the time being, if we can reset it for the SAP calendar for next Thursday, the 4th.
Granted. Position 26 was a plea, 27 was non-cross, 28 was a plea, 29, Colin Reynolds.
I believe that individual bonded out, Judge.
Yep, you're right.
He was released on the 22nd.
Correct. Thank you. Sorry, I should have read the next column on this name. Okay. To 30, Rodriguez was a plea, 31 Scales, all the way through 33 were pleas, 34 and 35 were null crossed. Next we have is 36, Christopher Smith.
Your Honor, I had indicated we're going to waive arraignment and plead not guilty on Mr. Smith. I'll file the appropriate paperwork today, Judge.
All right, this case is further notice for trial. 37 Waters.
He was released, Judge, on the 20th.
Okay.
I'm sorry, excuse me, Judge Law, we have Miss Abden back.
Okay, I'll be right with you. I've just almost finished. 37, Alante Waters, 38 and 39. These are all further notice for trial pursuant to the release. Position 40, Quan Webb was a plea, and 41, Wilcox.
Likewise, Judge, we're going to waive arraignment and a plea of not guilty, and I'll submit the proper paperwork later today, Judge.
All right. Position 41, Wilcox is further notice for trial. 42 and was a plea, Adidas Wy, and 43 was null crossed. We good? Okay. Going back to Miss Abden's case. For, let me get to the page. All right, Demetrius Hatcher. Yes, Miss Abden.
We're ready to proceed with the plea on both cases, Your Honor.
For both cases?
Correct.
All right. So with respect to position for case 23-7855E, since restitution is no longer on the table, is your client willing to accept the rest of the terms?
Yes, and we'd like the court to consider converting the fines to community service if Your Honor is inclined due to inability to pay.
I haven't made a decision on that yet. With regards to the 2019 offense of battery, substantial physical harm, 22 CR 003029E, the state is asking for him to serve 29 days credit for time served 1 day, which means he has 29 more days to serve at the jail prior to being on probation, which includes the anger management classes, stay away, and no weapons, no firearms included. How is your client? Is your client willing to accept those terms?
Yes, Your Honor.
Okay. Deputy ACDC, do we have any more cases at that location? No? Okay, just wondered. Thank you. All right. Ms. Falk, do you have one thought or another with regards to conversion of the fines to community service?
I'm not sure if they can be converted on the DUI. That's actually what I was looking at, because I think they are part of the statutory requirements. But if Your Honor will just give me a moment, I think as to the rest of them, yes, they could be converted. It's the DUI that I think is going to be a shall remain a fine.
Right. Well, the $300 fines on the hit and run. So
right.
It's not an obstruction charge, so
There is also a fine as to the DUI, the $600 fine, I believe.
that, right, I agree. Mr. Hatcher, given your significant driving history, given the open cases that you've had and your GCIC, I don't think you are very compliant with the traffic rules of the road. So in addition to the other conditions, I am going to impose the fine requirement. In addition to that, I'm going to require that you surrender your driver's license and that you have no driving while you're on active probation. Does he have his driver's license, Ms. Abden?
It is my understanding that he does, and I guess he would need to tell me if he would like to proceed with the plea.
Yeah, because he'll need to surrender his driver's license to probation or be subject to a revocation. Mr. Hatcher, so the terms of the probation is not only the conditions, but the fine as well as no driving while you're on active probation. These the terms that you'd like to agree, or would you like to have a trial?
Yes, ma'am, I agree.
You agree to the terms?
Yes, ma'am.
All right. Ms. Abden, do you stipulate to the factual basis, venue, and ID for both cases listed against Mr. Hatcher?
Yes.
All right, Mr. Hatcher, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Hatcher, have you consumed any medicine or alcohol recently?
No, ma'am.
And during the course of your conversations with your attorney as well as attending this proceeding, have you understood everything so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Are you entering this plea willingly, knowingly, and voluntarily?
Yes, ma'am.
And have you understood the terms under which you need to serve for probation?
Yes, ma'am.
Do you understand that you would be suspended from driving for the term that you are on active probation?
Yes, ma'am.
Do you understand that you have 29 more additional days to serve at the jail?
Yes, ma'am.
And once you enter this plea, this will be the final ruling in these cases, and there will be no opportunity to appeal or to set aside the sentences.
Yes, ma'am.
And do you understand also that pleading guilty to DUI can have negative consequences upon your any outstanding jobs that you have, any outstanding cases you have, as well as your residency if applicable?
Yes, ma'am.
Has your attorney explained to you that if you decide to enter this plea, you would have to give up your constitutional right to a trial before a judge or a jury, to be able to attend court with your counsel, to confront your accuser, challenge the witnesses and the evidence brought against you, present any mitigating factors or defenses if you choose to do so, and have the state try to prove the charges against you beyond a reasonable doubt? Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of hit and run, failure of the driver to stop or return to the scene of the accident, and one count of DUI, driving under the influence of alcohol, less safe?
Guilty.
Your sentence for the hit and run, for the hit and run is 12 months, which would be concurrent to the DUI, less safe, to serve 38 days, credit for time served 19 days. You'll be placed on probation once you are released. While on probation, you will pay a $300 fine, complete a defensive driving class, and that's going to be separate from a risk reduction program. You will complete a defensive driving class with a qualified school, and you can obtain the schools from the Department of Driver Services website or have a recommendation from your probation officer. While you are on probation, you're not to consume any alcohol, no illegal drugs, and not possess any weapons or firearms. The less safe charge is going to merge into count 3, and this would be a conviction for driving under the influence of alcohol, less safe. You'll be on probation to serve 38 days, credit for time served 19 days. Once released and you report to probation, you will need to undergo an alcohol and drug evaluation and submit yourself to any treatment that's required. That must be completed within 60 days of reporting to probation. You will also complete a risk reduction program, which is separate from a defensive driving program. You will also pay a $600 fine and complete 40 hours of community service. And the community service must be completed with any nonprofit agency that is not a church and not a school. Please understand that for your DUI case, in total, you would have to pay a $900 fine plus probation fees, plus any victim impact funds, as well as any court costs, and complete the programs as well as the community service. With respect to the 2019 case, how do you plead to one count of battery causing substantial physical harm?
Guilty.
For case 22 CR 003029E, your sentence is 12 months to be put on probation to serve 30 days, credit for time served 1 day. You will serve 29 days at the Fulton County Jail, after which you'll be released and placed on probation. Once released from jail, you must report to probation at the immediate business day, which will be a Monday, a Tuesday, or a Thursday. That's when you will begin probation for both cases. Probation office is located at 132 Mitchell Street in downtown Atlanta. At your first visit on probation, you must surrender your driver's license and you are suspended from driving while you're on active probation. For the battery charge, you will complete a 12-week anger management program, and that must begin within 30 days of being released. You will also, you also complete 40 hours community service, which will be concurrent to your DUI case. So in other words, you only have to do one set of 40 hours of community service. At all times while on active probation, you're to have no contact with David Kenneth Jolly, and you're to stay away from the bar known as Blue, located at 262 Far Road in Northeast Atlanta. Again, no illegal drugs consumption, no alcohol consumption, and you cannot own a weapon or a firearm. You will be on active probation after you've completed your jail time, and that will be for the remainder of the 12 months. Thank you. Anything else, Ms. Abdon?
That's all. Thank you, Your Honor.
All right. This be recorded as a plea. Medical, who do we have?
Position through number 6, Mr. Caldwell. First name D Nice.
Are you Mr. Denise Caldwell?
Yes, ma'am.
Mr. Caldwell, first of all, I'd like to remind you of your right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one would be appointed to represent you. Presently, we had appointed Owen Lynch as your counsel, who had filed a motion to withdraw on the grounds that he can no longer serve as conflict counsel. However, his motion was not in compliance, so he's going to have to refile his motion. Since Mr. Lynch may be unable to represent you and he is not present, I'm going to reset your case to January 4th, 2024 at 9 a.m. and I'm going to appoint attorney Maureen McLeod to represent you. She will speak with you before your next court date. Do you understand, sir?
I thought I had their attorney.
No, public defender's office is not authorized to represent you. You're represented by conflict counsel. So your attorney was Owen Lynch. Does that name ring a bell?
No.
Okay. Well, Ms. Abdon, were you under the impression that the public defender's office was representing him?
So for the first, it's my understanding for the second case, that, you know, he had appointed counsel. It may have been a conflict due to the co-defendants, but as to the first case, I thought we would be able to proceed, but it sounds like he will need conflict counsel for that as well, Your Honor.
I'm going to have Ms. McLeod represent him in all cases. It's going to be very otherwise confusing to do these piecemeal representations.
No problem. Thank you, Your Honor.
Okay. Mr. Caldwell, please remember this name, Maureen McLeod.
Do I still have my bond for these FTA?
You do have a bond. Let me check and see. So you have one case, 17 CR in which you were charged with suspended and revoked license and failure to maintain lane. And you have the second case, 22 CR, giving false information and loitering and prowling. So
When-
let me check on the bond situation.
Your Honor, we're showing there's $4,000 total surety bond, $2,000 on each case for the failure to appear. But that is not actually, I mean, he could address that, but he's actually being held on no bond for several felony charges.
Okay. Yes, Mr. Caldwell, on your bench warrant cases for failure to appear in court, you have a $4,000 cash bond.
I didn't miss no court. I was locked up when they gave me a court date for these.
Let me see.
I was in pretrial.
Just 1 second, please. Yeah, you did not appear before Judge Morrison on June 3rd, 2023. July 3rd, 2023. Where were you detained?
Was that pretrial? And I think I locked up in Wright Street too.
You said you were locked up. Where were you locked up?
In pretrial detention center.
I don't know what that is. Pre-trial.
ACDC, sit back down.
I'm sorry, who's speaking?
ACDC, sit back down to jail.
Okay, you were at ACDC? Okay. July 3rd, 2023.
Then the attorney I had for this case told me I didn't have no court date. And the Burnham County told me I had no court date.
I have that you were booked in on December 14th, 2023. And before that, you were booked in at the Fulton County Jail on November 22nd, 2022, and released on November 24th, 2022. So I don't know where you were between November 24th, 2022 and December 14th, 2023. So if you have a record of you being at ACDC on July 3rd, 2023?
I think I still have it.
Okay. If once Ms. McLeod speaks with you, if she has that information, we can revisit your bond. We will see you on January 4th. The other thing is you have a felony case that's holding you at jail in which you are in a no bond status. So please let Ms. McLeod know that.
Okay.
Thank you.
Next, we
All
have
right.
numbers 17 and 18, Mr. Hill.
And that in courtroom too?
Yes.
All right. Jail court iPhone, I'll be with you shortly. Please mute your screen.
Judge Law, if we can finish, we have 2 more cases.
Oh, no, I was just wanting to mute jail court iPhone. That's all. I'm still with you, Francois. Don't worry, I'm not running anywhere. Okay, and this is position 1718. Are you Mr. Anthony Hill?
Yes, ma'am.
All right, Mr. Hill, you have a case on position 18, 21 CR 3536F, accused of battery family violence from August 3rd, 2019. You've also got a bench warrant matter, 23 FTA 1175, from an August 2nd, 2023 incident. Mr. Hill, you've been advised of your right to remain silent, and your attorney is going to be Ms. Rachel Abden. This is going to be a non-negotiated plea, which means that the prosecution and the defense are going to give me an alternative plea recommendation. Mr. Hill, I will let you know which recommendation I will accept based on these circumstances and your history, if you have one. After I've given you my selection, you have a right to either proceed with the plea or to demand a trial. So Miss Falk, sorry, I was wondering where you are on the screen. There you are. Okay. Yes, what's the state's recommendation?
State's recommendation on this case, Your Honor, is as to Mr. Hill is going to be 12 months, serve 36 days, credit for time served 18 days. That's going to be from August 3rd, 2019 to August 4th, 2019, December 13th, 2023 to today, balance probated, family violence intervention program, a $500 fine, no further contact with Mahia Dowdle, excuse me, and stay away from the Atlanta motel at 277 Moreland Avenue, no alcohol, drugs, or weapons, and no firearms. If I can just inquire with the defense, what is the basis for the non-negotiated plea? Because it's clearly not the jail time.
The only issue is the fine of $500. So we just wanted to, something the court would consider and bring that to community service and would like to be heard on that. Aside from the fine, we're ready to proceed with the plea.
State's agreeable to 80 hours of community service.
In lieu of the fine.
Yes, and we would ask that the defense stipulate to venue, factual basis, and identification for the purposes of the plea.
Ms. Abden, is your client in agreement of 80 hours of community service in lieu of a $500 fine?
Yes, Your Honor, thank you.
All right. And you so stipulate?
So stipulate.
All right. Mr. Hill, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with your attorney's services?
Yes, Your Honor.
And is anyone forcing you to plead guilty today?
No, ma'am.
In order to enter this plea, you would have to willingly and knowingly give up your constitutional right to a trial, to be able to confront your accuser, challenge the evidence brought against you, present any defenses or mitigating factors if you choose to do so, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And how do you plead to one count of battery family violence?
Not guilty. I mean, guilty.
Well, let me ask you again. How do you plead to one count of battery family violence?
I plead guilty.
Your sentence is 12 months to serve 36 days, credit for time served 18 days. If you have no other holds at the jail, you should be released within 24 hours. In that case, you would have to report to probation next Thursday, January 4th, before 3 p.m. While on probation, you will complete a domestic violence intervention program, and you must enroll in that program within 60 days of being released. You are also required to complete 80 hours of voluntary community service, and that must be completed at any nonprofit agency that's not a church and not a school. At all times, you have to have no contact with MIAJA, which I think is Maya Dowdle, which means staying 200 yards away from Ms. Dowdle and not communicating with this person in any way, form, or manner. Also stay away from the location of 277 Moreland Avenue in Atlanta, Georgia, which I think is called the Atlanta Motel. While you're on active probation, you must report to probation every month, and you're not to consume any illegal drugs, no alcohol, and not possess any firearms or weapons. Thank you.
And Your Honor, if we could just sound for Ms. Dowdell, I don't believe she is here, but I just want to sound for her out of an abundance of caution.
Okay. Maya Dowdell? All right. Next case with Ms. Abden.
We're gonna do numbers 19 and 20, Mr. Jarrett. Bill, you're gonna have to.
Is that a jail court? No, that's in courtroom too. Okay.
Yes, it is, Judge. What position? 19 and 20, Jarrett.
Are you ready to proceed, Ms. Abden?
Yes, Your Honor, we're ready to proceed on the negotiated plea.
Okay. Vernon Jarrett is case 23 CR 3931Y, accused of obstruction of an officer from April 21st, 2021. He has a bench warrant matter from October 19, 2023, and case number 23 FTA 1183. With regards to both matters, Mr. Jarrett, you have a right to remain silent as advised, and your attorney is Rachel Abden. This is going to be a negotiated plea. May I place you under oath? Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Mr. Jarrett? Do you so swear?
Yes, ma'am.
Thank you. Ms. Polk?
Yes, Your Honor, this is a time served plea. The defendant has actually served 365 days from April 21st of 2021 to April 20th of 2022 on this case. And for that reason, this state can only recommend time served and closed. We are also doing a null pros on position 20 as a part of this plea. The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
That's stipulate.
Mr. Jarrett, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood everything?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has it been explained to you that if you enter this plea of guilty to obstruction of an officer, that your jail time is now completely served? But if you don't want to plead guilty, then you will have a right to a trial where you can face your accuser, challenge the evidence brought against you, and have the state try to prove the charge against you beyond a reasonable doubt. Do you want to plead guilty or do you want to waive your constitutional rights? All right, I'll accept your guilty plea. Your sentence is to 12 months to serve 365 days. Credit for 365 days. Your time is concluded. Your case is closed. Thank you.
Thank you.
Judge Law, if we can do our last case in here so we can start our misdemeanor pool. Go ahead and have a seat for me, Jared. This is gonna be number 22, Lipsy.
State has reviewed Ms. Abden's request and submitted a null process to all of the cases on the calendar.
With regards to Marcus Lipsy.
Yes.
All right.
The defendant is currently, just to give Your Honor brief background, the defendant is currently enrolled in PAD. And as part of that, we have agreed to a null process of the FTA, the underlying charge, and a disorderly conduct offense from 2021.
Okay. Mr. Lipsy, you have one charge of criminal trespass from 23 CR 5911A, a disorderly conduct charge from 21 CR 3757F, and a bench warrant from 23 FTA 1186. Based on the enrollment in the PAD services, all three cases are closed out. There are no pending cases against you. Thank you.
Thank you.
Thank you all.
All right, you guys go ahead and line up coming on this floor.
All right, I have position 24, Octavius Mcle. What are we doing in that matter?
That is a non-negotiated plea, Your Honor, as to the Family Violence Intervention Program. Aside from that, we have no objections to the state's recommendation.
A non-negotiated plea as to the FWIP, is that what it is?
Yes, Your Honor.
Okay, jail court iPhone, is that Octavius Mcle?
Yeah, ma'am.
Okay, Mr. McCownley, my name is Judge Lowell, and your case is 23 CR 8026F, accused of simple battery family violence. That's the charge from July 19th, 2023. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Rachel Abden is representing you. This is going to be a non-negotiated plea as the defense has an issue with the condition of domestic violence intervention program. So Ms. Polk, in addition to that requirement, what's the state recommending?
Your Honor, the state's recommendation on this case is 12 months served, 28 days, credit for time served, 14 days. That's going to be from December 15th, 2023 to today. MHET, 40 hours community service, no contact with Tyler Williams and the minor children of Miss Williams, and stay away from 780 Magnolia Way Northwest, apartment 205, no alcohol, drugs, or weapons, and no firearms. At the conclusion of our recitation of the facts and the history of the defendant, we would like to sound from Miss Williams. So, Your Honor, this offense happened back on July 19th, 2023. Miss Williams stated she got into a verbal argument with her boyfriend, the defendant, that turned physical when he slapped her. Her 3 children, KW, SM, and LM, were present when the incident took place. They were 2, 12, and 8 respectively. Miss Williams then stated the defendant left the location, came back around 12 a.m. and broke a bedroom window before leaving again. According to Miss Williams, she stated that the defendant has some MH issues, which is why we made that recommendation. The defendant also has an open 2023 cruelty in the 3rd degree, battery, family violence, and driving without a valid license in DeKalb County that, from my review, still remains open. And for that reason, as well as for the fact that this offense did involve family violence, we are asking for FBIP as a condition of this case. That's all for the state.
And Your Honor, as for the DeKalb County case, it's my understanding from my client that he already entered a plea in that case. As part of that plea, he was required to also do anger awareness classes. I believe it was either 8 or 12 weeks. I don't remember. I did reach out to the public defender's office in DeKalb to see if they can maybe provide me with some information about it so we can confirm that. I have not heard back yet. So that is what my client is telling me. Considering that the FVIP is not statutorily required for simple battery family violence, and he's already required to do anger management and other requirements for the other case, I am requesting that Your Honor consider perhaps additional anger awareness classes or just doing away with the FVIP requirement for him. As for the MHET, I just want to confirm with the state if they would be okay with that being outpatient. And if not, then I would need to speak with my client.
State doesn't have a problem with an outpatient evaluation, no.
And other than that, we have no objections to the recommendation, Your Honor. He tells me that he is looking forward to getting out and dealing with his MH, and so he had no objection at all to the MHET. It's something that it's one of his goals, is what he described it as. And he also was previously working. He recently lost his job, and so he plans to get out and try to get a new job. He also has a newborn who was born October. She's 2 months old. And so I'm asking Your Honor to take his familial obligations and financial obligations to that child into consideration. And that goes for the FIP as well, as it costly and it's time consuming. And he quite honestly can't afford it, Your Honor, until he does find a new job. And so that is what I'm asking Your Honor to consider. And other than that, he's agreeable to plead guilty.
And Your Honor, I will say, I think the simplest solution here is if the defendant completed FVIP, he could provide the proof that he has completed this year FVIP to probation, and then that would resolve this issue of whether he has to do FVIP or not.
I don't think it was an FVIP imposed by DeKalb County. She said it was anger management classes.
Correct. And it was just entered ASG Fall very recently. He said that he just came from DeKalb where they pled this out.
Okay, because I did not see that in his GCIC that he had completed that case.
Yeah.
So,
and if you have, I obviously don't have access to it. You would probably be able to see what the terms are. I can't yet.
I'm going to be candid with both the PD and the court. Had I known that the defendant had resolved the family violence and it wasn't just an open case, the state's recommendation would have been higher. So the state is comfortable with the recommendation where it is, especially in light of the fact the defendant has entered a plea to family violence battery.
Okay, so a couple of questions. DeKalb County case, when was the disposition entered? Anyone knows?
As I've stated, I don't have access to that. I've reached out to DeKalb County.
And how many classes did they require him to complete for anger management?
5.
5?
Yeah, ma'am. And they terminate my probation once the 5 classes completed.
Okay,
And-
good. So now you face the consequences in Fulton County. Next
ma'am.
question. Who is the mother of the newborn?
Tyler Webb.
The complaining witness, Your Honor.
Who is the alleged victim in this case?
Correct.
And who was the victim in the DeKalb County case?
Tyler Webb.
Your Honor, state would like to just withdraw this recommendation. I'm very uncomfortable, especially in light of the fact that this involved the same victim and he has pled to these charges in DeKalb County.
So
The plea offer is withdrawn, Ms. Abden. Mr. McCownley, the state has withdrawn the plea offer on the grounds that you just pled guilty to a family violence case in DeKalb involving the same victim. And I'm not satisfied that the disposition in the DeKalb County case even covers the circumstances of this particular case.
Your Honor, would you be, I apologize, would you be agreeable to possibly reset this case so we can all get on the same page with what is happening in DeKalb? This is just what he told me. We can't confirm.
I totally, yes, I
Yeah,
totally
Because
agree.
I don't want this to be reset to a trial and him not have the opportunity to plead.
All right. Mr. McCownley, you don't qualify for a waiver of domestic violence intervention program. And on the grounds that this would be the second case involving the same victim, my concern is that I would not even accept the recommendation as it currently sits. So I'm going to reset your case to January 4th, 2024. And hopefully by then, both sides are familiar with the disposition as well as the allegations that were whether the allegations in this case parallel the allegations in the DeKalb County case. So case is reset to December 4th. Thank you. Sorry, January 4th, 2024.
Thank you.
Next we have position number 13.
This is Cardell Copeland. Mr. Copeland, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Rachel Abden. Your case is 17 CR 023694J, and this is involving a traffic-related matter from December 1st, 2016. In that particular case, you were cited with the following traffic matters: operating a vehicle with no license on person, no insurance, suspended or revoked license, and the vehicle being operated apparently without a current license plate or decal. I understand that Mr. Copeland intends to enter a not guilty plea. Let me just look at this particular case. I'm just curious to know why.
And Your Honor, if I may possibly be put in a breakout room with him, he stated that there was an Atlanta traffic court case with these same charges. I was able to find it, but I was not able to confirm what happened. It appears, and I have the record, I can send the court and the state a copy of what happened in that case, but it appears that a lot of things happened, but along the line, they allowed him to reinstate his license, and then somewhere down the line, this case got bound over to state court. So I'm not really sure why, and in order to do that, I'm gonna have to request the actual records or more information, because all I have is the printout from the website. So I would like to discuss that with him, Your Honor, if possible. And then in addition to that, he also has another traffic Atlanta City case, City of Atlanta case, which is how he ended up in Fulton County on this hold, on these open warrants. So he was released on a signature bond on December 18th in that case. And again, I can send you in the state a copy. And he has not seen a judge for this for this particular case within 72 hours. And so it is a reverse.
That's a lot of stuff going out there, Mr.
I'm sorry.
Abden.
Yeah.
All we know is that the accusation was filed on September 18th, 2017. And I can only at this present time assume that the case was bound over from the City Court of Atlanta pursuant to an entry of not guilty plea. That is a possibility. That's a very high possibility. I'm not sure, but you can definitely correct me if I'm wrong. His court date was with Judge Besson on February 27, 2018, in which it was recorded as a failure to appear. A bench warrant was issued on March 6, 2018, and the case has been dormant since March 6, 2018. That's where we are right now. Now, what has transpired between March 6, 2018 to the present time, that is, I'm just as curious as you about it. In the meantime, no, right a minute, just a minute, Mr. Copeland, please remain silent. Right now, in the meantime, if there have been other matters involving Mr. Copeland, that is something I'm really curious to find out about. But Ms. Tyson, do you have a GCIC on Cardell Copeland?
Yes, Your Honor, I do. No, 1 second.
Position 13.
Yes, Mr. Copeland, he has 8 arrest cycles in the state of Georgia beginning in 2001. His last arrest was out of Jonesboro, and it was for driving while license suspended or revoked. He took a NOLO plea on that case, April of 2016. He does have 1 FCA, which was his last arrest in Fulton County. That was December 18th of 2023. And he does have 12 arrest cycles out of Kentucky. He has a misdemeanor conviction for theft by deception. It's 4 counts of theft by deception. That disposition date was July of 2017. And he does have another, misdemeanor conviction for a theft by deception from November of 2017 in Kentucky. And it looks like he may have a possible pending case out of Kentucky. It looks like it's for, driving violation, speeding 21 miles per hour over limit, possession of controlled substance, 1st degree, cocaine. No dispositions listed on the GCIC for that case. And his last arrest was February 23rd of 2023. And that was for a failure to appear. No other information is provided with that failure to appear.
Was that in Kentucky?
Yes, it was in Kentucky. Yes.
Okay.
And that failure to appear was from February of this year.
Okay. And do you have the date of incident for the Kentucky matter for the cocaine possession and speeding?
Yes. November 22nd of 2021.
Okay. All right, that is some of the alleged activity involving Mr. Copeland. Ms. Grace, if you could place a jail court iPhone and Mr. Abden, are you going to be on your laptop?
Yes.
Okay, and PD Rachel Abden in a breakout. Ms. Abden, I think all you have to do is just go back to the same breakout room.
There's nobody in here if they want to just place courtroom 2 in a breakout with.
Oh, I was going to work with Mr. Haddad to go over the rest of the calendar.
Perfect. Okay, yeah, so my laptop would be great. Thank you.
Okay.
Okay, Judge.
And Mr. Haddad will just take notes for Ms. Abden.
Yeah.
And then after that, we'll go into, Mr. Murphy, good morning, sir. We'll be addressing the 11 o'clock calendar very soon. Okay. Mr. Haddad, this is just over the, we've already gone over your portion of the SAP calendar. On the remainder portion, position number 1 is arraigned and further notice for trial. Position 2 case is reset to January 4th, 2024, along with the 6 other open cases. Ms. Polk, have you had an opportunity to let Ms. Strong know the 6 other cases?
I have, Your Honor, and I believe it turned out to be 8 total, 7 or 8
Okay,
total cases. But yes, I did go ahead and send those over.
okay. Position 3, 4, 5, and 6 are reset to January 4th, 2024 for Mr. Caldwell to speak to Maureen McLeod. Position 7 is a waiver of arraignment and further notice for trial. Same announcement for position 8, 9, and 10, and 11, and 12. Same defendant. Waiver of arraignment and further notice for trial. Position 13, Cardell Copeland, we are on hold for that. 14 is, and 15 are reset to January 2nd, 2024. Position 16, Hatcher was a plea. 17 is null cross. 18 is a plea. 19 is a plea. 20 is null cross. 21, Maurice King is reset January 4th. 22, 23, Marcus Lipsy are null crossed. 24, McCownley is reset to January 4th, 2024 for a possible plea or arraignment. And the remainder of the cases were yours, Mr. Haddad. I've already addressed those, including Leroy Parham. Would that be correct?
That is correct, Judge.
All right. Just to go over the probation revocation calendar. Position 1 is commuted to time served. Position 2 is closed out. Position 3 is closed out. Position 4, Kayla Frasier is, I think it was commuted to time served. Position 5 is closed out. Position 6, probation, it was closed out. Position 7, probation, he continues on probation. Position 8 is closed out as a result of that. Position 9, Ridley, probation's revoked. He needs to complete an additional 100 days. And that was involving Mr. Ridley. Any questions?
Your Honor, just on position number 3 and 4, Ms. Frasier, I believe technically she was revoked for 27 days.
Okay, but she already served that time, correct? No, she had revoked, yes, revoked it, but she's in jail on another matter, so she's going to serve out that time. You're correct.
Thank you, Judge.
Okay, we'll just.
May I be excused?
Yes, Mr. Haddad. Enjoy your New Year's. Thank you.
Thank you. You as
See you
well.
next year.
All right.
Happy New Year. Okay, who are we going to place in the competency calendar besides myself and Ms. Folk and Ms. Ogden? Anyone else? I have Kia Burgess. And anyone else joining us? Okay.
I believe that's it, Your Honor.
Okay, Mr. Dennis Murphy. All right, let's see. Miss Grace, can you place Miss Falk, Miss Burgess, and Dennis Murphy and me into a breakout, please? We'll come back for Mr. Copeland's case.
Okay, Judge.
Miss Grace, have they started the competency calendar?
Yes, I was just about to unmute to ask, do you need to be placed in there?
Yes, I do. Thank you.
Okay.
Officer Goldie. Officer Goldie on the jail court iPhone. They are doing a breakout session for the conference calendar for Eric Jackson, I guess.
We finished the breakout session.
Oh, okay. For the conference calendar?
Oh, no, we're still
Eric
doing what's his name? Copeland, position number 13.
That's what I'm saying, but they are doing a breakout session now for the conference calendar. That's why you all waiting.
Yes,
Oh.
the judge says she will address Mr. Copeland after she come out the breakout from the
All right,
conference
so
calendar.
do I still have to go get Eric Jackson?
You probably need to wait because they discussing him now.
Okay.
All right.
License in one state before you can get it in another state, right? Right. I have a license right now.
All right, we are back with Mr. Copeland, who is position 13 on our regular calendar, regular SCP calendar. And yes, Ms. Abden, let's see now. There was a plea offer for this case. I guess your client is not accepting it?
No, Your Honor, he wants to enter a not guilty plea in this case, and be heard on bond.
All right. May I first go ahead and arraign the case?
Yes.
Okay, and do you waive a reading of the accusations?
I will waive the reading of the accusations. I'll file that in.
Okay. Mr. Cardell Copeland, this is 17 CR 023694J. In this particular case, accusations were filed by the Solicitor General's Office of Fulton County against you, and the accusations involve the following 4 charges stemming from a December 1st, 2016 traffic incident in Fulton County, Georgia. The charges are failure to have license on person, operating a vehicle with no insurance or no proof of insurance, operating a vehicle with a suspended or revoked driver's license, and operating a vehicle that has an unregistered decal or license plate. With regards to the 4 misdemeanor charges, upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecutor would have the complete responsibility to prove the 4 misdemeanor charges against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the prosecution does prevail, you could be convicted of 1 or more of these offenses. With regards to the charges brought against you, 2 of the offenses could be a fine of up to $500. And with regards to the no insurance and suspended license, it could be a penalty of up to a year in prison and or up to $1,000 fine. These fines and sentences could be served together or consecutively. It could also involve a suspension of your driver's license. Given this information, how do you plead? Mr. Cardell, given this information, how do you plead?
I'm not sure. I'm not sure at this time. I need to speak with my attorney. I don't understand the situation because I have a Kentucky driver's license right now.
I'm not convicting you of these offenses, sir. These are open, active charges against you. You are legally presumed innocent of these charges. I'm just giving you, once you've entered a not guilty plea, the case will be scheduled for trial. At the time of the trial, you have absolutely no responsibility and no burden. The prosecutor, which is the Solicitor General's Office of Fulton County, has the burden and the responsibility to prove all these 4 charges against you beyond a reasonable doubt. If the prosecution is unable to carry its burden of proof, then you will be acquitted of these charges and the case will be closed. However, if the prosecution does carry its burden of proof and the trier of fact, which could be the judge or the jury, does find you guilty of 1 or more of these offenses, you could face a penalty of up to a year in prison and or up to $1,000 fine for some of these convicted offenses. And it could also involve a possible suspension of your driver's license, which does go nationwide. So this is the information I'm giving you of what could possibly happen once the case goes to trial. You could be acquitted or you could be found guilty, depending on whether the prosecution carries its burden of proof. Given this information, how do you plead?
Not guilty.
Your case has been arraigned and is going to be further notice for trial. All right, so now your attorney is going to address the question of your bond. Yes, Ms. Abden.
Thank you, Your Honor. So for this case, the accusation was filed in 2018. It's my understanding from my client and from the record of the Atlanta City the court case of the same charges, is that it appears that he was working on resolving it. And at some point, there is a line in there that reads that he may go to pick up his license. So again, I'm not really sure what happened, but it seems that at some point, it got bound over. So he was under the impression that this was over with, done. He was done with it. That's what they told him over the phone. That's what he communicated to me. And at this time, that's all the information I have, and I've sent it to the court in the state. So like I said, this case was filed in 2018, September of 2018. There was a notice and it was returned to sender on February 6th of 2018. Subsequently, the arrest warrant and the bench warrant were issued in this case. So he has very strong ties to the community, Your Honor. He has a lot of family here, and we can go into that in just a moment. But he moved from here to Kentucky for work sometime in 2018. And so he wasn't here. He thought this was over with. It's not that he wasn't trying to show up to court for his obligations. He didn't receive adequate notice. That's all that happened. So now he came back to Georgia in December, the beginning of this month, for a job interview in Sandy Springs. When he left the job interview, he was pulled over for the other case I sent to you and the state. It's the 2023 City of Atlanta case where he received a signature bond on December 18th. From that point on, he's been in jail. He's not spoken to anyone. He missed Christmas with his family and grandchildren. He wasn't even able to contact anyone to let them know that he's here. And so given the fact that he was not brought for a first appearance in this case, I believe this is a Riverside issue, and I'm requesting that he be released on a signature bond and we enter a not guilty plea.
How is it Riverside on December 18th?
So if you open up the second case I sent, it's the City of Atlanta, 23 TR 089356. He received a signature bond on that case on December 18th, 2023. He should have, from that point on, it's my understanding, he should have been brought before a judge within 72 hours on this case that we're talking about.
On a bench warrant?
That is my
Riverside applies to a bench warrant?
And Your Honor, the state would respond, Riverside absolutely does not apply to a bench warrant. It applies to first appearance on a first arrest. This is the defendant's subsequent arrest on a bench warrant. If that were the case, every single bench warrant we have would be a Riverside issue because the defendant wouldn't have had a first appearance on a bench warrant.
Correct. But I guess my point is that he never received notice of this case, Your Honor, as I've stated. He thought it was resolved. Again, he's been in jail for, since December 18th without being able to provide anybody notice on something that he thought was resolved. This clearly was a misunderstanding, Your Honor.
Was he in Kentucky in 2018?
Yes.
Okay. Thank you, Ms. Abden. Ms. Falk, anything to add?
Yes, Your Honor. As far as, and I'm kind of going through all of this as we go. The 912 form, I pulled up what the 912 form looks like. And that is essentially where, according to this form, it's notice to failure to comply with the terms of a citation. So I'm not sure what happened in 2017. The case was clearly bound over to the state court in 2017 and then appeared before us. We then placed the case on the calendar for court, and the defendant failed to appear. I will say that based on what I'm looking like on the entry on March 10th, 2017, it looks like the defendant entered a plea of not guilty. It says bound over to Fulton County State Court plea not guilty. On March 10th, 2017, at which the point the case was bound over. So that is the case, then the defendant did in fact know that he was still going to court because he pled not guilty and the case was then bound over to state court. As far as, I guess I'm not addressing the Riverside issue since that's a non-entity at this point, but as far as his history is concerned, and let me just go into that.
No, I've already heard his history. That's pretty much what you've got then, that it was a bind over from City Court of Atlanta.
Yes, and it looks like he pled not guilty on March 10th and then it was bound over. So I'm not sure how he's arguing he wasn't aware that the case was bound over since he entered a not guilty plea and had it bound over.
Thank you.
And
No,
as
no.
a.
Ms.
as
Abden,
a-
no
Okay.
more. No more. Mr. Copeland?
Yes,
You
ma'am.
had a City of Atlanta traffic court case. And this is not your first rodeo in traffic court. So don't BS me anymore, all right? Do not BS me anymore. This is not your first rodeo in traffic court. Your history in Kentucky establishes that. I don't think you have a significant history in Georgia, but you are not a novice to traffic court. I myself can open up your City of Atlanta cases, and I do not open up City of Atlanta cases because I have no reason to do so. But it just took me 2 clicks to get to your case. 16 TR 151431, City of Atlanta versus Copeland, where you pled not guilty. And when you plead not guilty in the City Court of Atlanta, your case gets transferred to the State Court of Fulton County, where then you have an obligation to make sure that the correct address, contact information are available for the State Court of Fulton County to reach you and show up in court. I don't know whether you had provided the correct contact information, but don't BS me. You had an open, active case with the City Court of Atlanta. It was not over. It was not closed. It was not dismissed. It's open and active. You pled not guilty and the case got transferred. So means you have an active case. You did not show up in court and you got a bench warrant. That's why you are sitting in jail today, because you did not show up in court in Fulton County. Now, there is no Riverside issue with regards to you. Because of your failure to keep up with your open cases, because of your initial decision to plead not guilty, you were responsible for making sure you show up in the State Court of Fulton County, which you did not on February 27, 2018, and Judge Besson correctly issued a bench warrant for your arrest. Now, given that you have already been in custody, and I just want to make sure I read off the correct numbers, for 11 days, because I don't know whether because you're not able to make the $4,000 bond that Judge Besson had issued, or whether you have any other holds. But you and I are now on the same page. You have an open, active traffic case that stemmed from a 2016 City of Atlanta matter. Would you agree with that?
Yes.
And you and I both agree that you need to respond to future court proceedings. And that means that you need to give us your correct address, email, phone number at all times. Would you agree with that?
Yes.
On the unregistered vehicle operating a vehicle, improper license plate or decal, that's going to be a $500 signature bond through the jail. On the suspended and revoked license, that's going to be a $1,000 signature bond through the jail. On no valid insurance, that's going to be a $1,000 signature bond through the jail. And failure to have license on person is a $500 signature bond through the jail. That's a total of a $3,000 signature bond through the jail. No driving unless Mr. Cardell Copeland has a valid and active driver's license issued by any state in the United States, even including Puerto Rico, Hawaii, or Alaska. As long as it's active and valid, he can operate a motor vehicle. But if it has been suspended, he cannot step behind the wheel of any car. And the vehicle that he operates must have valid insurance and proper registration at all times. He must also provide us with a current mailing address, email, and phone number at all times. If he changes it, we are his new best friends. We are supposed to find out first before anybody else in writing. All right, Ms. Abden, are we ready for, so this case is going to be released on bond. If he has any other matters holding up him at the jail, that's for another judge to address. But,
Thank
Ms. Abden, we ready for our, competency cases?
We are.
All right. So, let me see.
My
I'm gonna
license.
do- Yeah, we are
I'm
going
sorry.
to go back into the same breakout room. Join
The li-
breakout.
The license that I have now, the Kentucky driver license I have now.
You're
yeah,
good. It's
I
not
can drive.
suspended. Yes, so long as it's not suspended.
No, they're not.
All right, you're all good then.
All right. I'm
Thank
going to
you.
breakout 4.
Miss Grace, I'm sorry, I also need to be in the breakout room.
You should be able to let yourself back in. That's what she was telling you. She's going back into the same one, but let me look at it as well.
Oh, I see. I'm so
You see?
sorry.
Okay, that's okay.
Miss Grace. Hello. Miss Grace. Retrial.
This Miss Grace.
Hey, Miss Grace, so put for position number 13, was it a SOB bond 3,000?
Mm-hmm. Yes, through the jail.
Thank you.
You're welcome.